Maybe less Lordship.
Yes.
Lordship, I beg to mention item number 18 of the hearing.
18.
18, 1-8.
Yes.
Lordship, may I agree that the matter may be listed after 1 week. I have some personal difficulties today.
You're for the appellant.
No, Lordship, I am for the.
Have you informed the appellant?
He's on his way. I would not get a line.
So then,
He was on his way, but my engineer gave spoken
so you might reach for this matter only, probably.
that I don't know.
Hmm.
But due to the disruption in line,
Okay, no problem. I've heard you. So let him come if he's on the way.
yes, I was told he was on his way.
Okay. So then, wait for some time. We'll adjourn only. But then let him come.
All right.
Okay.
May I please, Your Lordship? I beg to mention hearing item 15, 16, and 17, Your Lordship. Lordship is joint prayer, Lordship.
Yes.
If this matter is resolved on Tuesday, Lordship, next week.
Hmm?
On Tuesday, next week, Lordship.
You're for?
I'm for the petitioner, Lordship.
Okay. Miss
Esther, Your Lordship.
Lana Counsel for the petitioner, prays for listing this matter after a week.
Lordship, it's a joint prayer, actually.
Joint prayer.
Yes, Your Lordship.
Okay. Okay. On the with the consent of the other side.
Yes, Your Lordship, government.
The prays for listing this matter after a week.
On Tuesday, Lordship.
On Tuesday,
Yes,
it's a
Your
fixed
Lordship.
matter.
Yes, Your Lordship.
It will be difficult then in that
Next
case.
week.
We'll say next week.
Your Lordship.
Fixed matter, normally what happen is that the people think that since it is a fixed matter, so it will take time. So we'll not say fixed matter.
Your Lordship.
Okay. The least is, the prayer is allowed, least is matter next week, after a week. Okay.
Much obliged.
There is a mentioning Lordship.
Yes.
Item number 5, Mrs. Path Projects and versus Mrs. Balaji Enterprises.
Okay.
I am praying for adjournment, my lords.
Okay. You're for
I'm appearing from on behalf of petitioner.
listener. Okay. Item 5.
Item number 5, Path Project versus Balaji Enterprises.
Yes.
Lordship, I'm for the responded in this.
Respondent.
Yes.
Any objection?
No, Lordship.
Okay. Mr. You are Mr.
Rajesh Kumar, my lords.
Rajesh Kumar, Lana Counsel for the petitioner. Praise for when do you want?
My lords, kindly put it after in July, probably, because there is a settlement between the parties are going on still.
Okay.
Okay.
Praise for listing this matter after during the month of July.
Yes, my lords.
Okay. The prayer made by the Land Council for the petitioner has not been objected to by Mr. Mozami, Land Council for the respondent. Accordingly, the prayer is allowed. List this matter during the month of July. Date to be fixed on the date fixed by the registry. Okay.
Lordship.
Probably, high lord, please.
Mr. Lordship, Lordship, I beg to mention item number 3.
Item
Number 3.
3.
Yes.
Okay.
Lordship, this matter relates to minimum scale of pay.
Hmm?
Minimum scale
Minimum
of pay.
scale.
Yes. And a committee has been constituted, but because of the model code of conduct for the ensuing ULB election, Your Lordship, I pray that the matter may come up after 26th of June.
Okay. Mr. Supamurthy, Waring Land Council for the petitioner is present. Ms. V. Sukri, Land Additional Advocate General, appearing for the respondent, submits that the committee to consider the case of the petitioner has been constituted. However, due to the imposition of the model code of conduct, the matter could not be taken up.
Yes.
And praise for listing this matter after
26th of June.
26th of,
after 20 yes.
26th of June. The prayer is allowed. List this matter after June 26th of June.
Okay. Much obliged.
Okay. Yes.
That is the Lordship.
Yes.
Lordship, I beg to mention item number 4, Lordship.
Item 4, Lordship. Here, Lordship, I am appearing for on behalf of respondent number 2 and 3, Lordship. Now the matter is before the MRC, and MRC has the committee has been constituted, and I think one supplementary post has been recommended, Lordship, for creating of one supplementary. Okay, so time may be given. So when do you want, you said? After 3 weeks, Lordship. After 3 weeks. 3 weeks, Lordship. Okay, this is also connected with the election or imposition of the model code of conduct? No. Not with that. Okay. So,
Lordship, we have no
okay,
objection.
Land Council for the petitioner, Mr. Mazza, is present. Mr. Zimomi, Land Council for the respondent, 2 and 3. 2 and 3, Lordship, submits that the committee has been constituted to consider the case of the petitioner, Lordship, and to create already created, Lordship, created one supernumerary force, Lordship, for to appoint force for the petitioner. So, however, it will take some time, Lordship. Okay, and praise for listing this matter after 3 weeks. The prayer is allowed, list this matter after 3 weeks. Okay.
Obliged.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item 9 on
9.
behalf of, yes, Government Advocate Pichano. We pray for 3 weeks' time to file a counter affidavit.
Okay, so I think for some respondent, service report is also still awaited in this case. So you are for respondent number
For the state respondents, Your Lordship.
state.
Yes,
There is also a private respondent here in this case.
I'm not sure.
No, not
This is not
okay.
my case.
So probably, okay. So where is for, have you informed the Land
Yes.
Council for the petitioner?
He was just here. I told him.
He was just here. So let him come. Well, adjourn, but then let
Your
him
Lordship.
be present, huh? Okay.
Obliged.
May it please your lordship,
Yes.
I beg to mention item number 1 and 2. Appearing on behalf of my senior and newcomer.
Okay.
Lordship, let this matter be listed after a week.
You are for the petitioner.
Petitioner, yes,
Miss
Rebecca.
Land Council for the petitioner, praise for listing this matter after
A week.
a week. So, Mr. Jimomi. Lana PP. And Mr. Sego for the Land Council for the respondent number,
The opposite party, Lordship.
opposite
Right,
party.
yes.
Okay. is
Respondent,
also-
by respondent.
Are also present. So, paid for by the Land Council for the petitioner, list this matter after a week. Okay.
Obliged.
Bless you.
No, not PP, huh? It's a petition, not criminal. Land Council for the state respondent, huh? Okay.
From the supplementary cause list for motion, item number 24.
Yes,
May I please, Lordship?
yes,
My lord, the present co-accused.
Hmm.
The petitioner is the younger brother of the co-accused here. She was arrested on 12/12/2023.
yes,
12/12/2023 at Senapati Bazar, District Senapati by the Manipur police while she was repairing her shoe in the shoe shop, barber shop at Poblar. Then without any information, she was taken to Senapati police station by the Manipur police. And the next day on 13/12, he was handed over to the Nagaland police at Senapati and taken back to Kohima and kept in narcotics cell. Thereafter, the narcotics cell case was, the present case was registered. She has been in the custody for 157 days, my lord. Yes. she was apprehended on the basis of the statement given by one co-accused. Here there are altogether 12 accused persons.
Okay.
The main two accused are one Mrs. Silas and Mr. James Chapal. And the main accused who was found, from whose possession the drug was found, was on bail now.
Okay.
Yeah, the main accused Silas Chapal is on bail. Then out of 12, altogether 7 are on bail. 7 are on bail. And in my case is that only based on the statement of the co-accused I was implicated. So therefore, I have a good number of judgment to support my argument.
Okay. What is the offense?
Offense is that
It's,
they
offense
alleged
section.
Section 21C of NDPS Act.
Okay. So
Yes, but
commercial.
commercial, but nothing was recovered from my house, neither from my house nor from my possession. Nothing. Just I was apprehended, as I say, I was apprehended based on the submission, based on the statement made by the co-accused under 67 NDPS Act, the statement before the police, which is not admissible at all.
Have you approached the trial court?
2 times it was rejected.
Rejected.
Yes. On
On
medical
what
ground.
ground?
She is still having a lot of spinal problems. She was taken to hospital on 18 January 2024, 30 January 2024
On medical ground.
on middle
On
ground.
health ground.
Yes.
So
Jail authority
that was considered
spinal. She was advised for surgery.
Hmm.
Jail authorities later
but
I have
the
annexed.
medical ground was considered
No,
while rejecting the bail by the trial court.
very much. On medical, so it was rejected.
So what is the new ground you have taken this time?
Now, my lord, the ground is that 2 things.
Hmm.
One is that from my possession, nothing was recovered. There are judgments, several judgment. I will show. Number one is that other accused had been already released. So on the principle of parity, one. Number 2, I was implicated without any material evidence at all. So I'm an
The
innocent.
entire thing was considered by the trial court also by rejecting your bail.
Yes. Bail was,
So now
in
my
fact, law,
question is, what is the new
fact,
ground you have taken this?
lower court case was argued by another lawyer. Yes, not by me.
So only the advocate has changed.
No.
And
No.
then- Okay.
Don't change it.
Then
The finding of the trial court was wrong.
this is bail application or
Bail application, my lord. So therefore, I have come under 439 CRPC,
Hmm.
my lord. If lordship may read the bail application,
Bail.
may read the bail application, ma'am.
What thing you want to read? Bail application
Yes,
before this court. This petition.
yes.
Yes, what you want to read?
I'll just read out
Now
the
just tell
facts.
me, what is the stage of the investigation? Charge sheet file?
Not yet,
Okay.
not yet. Though it has expired more than 157 days.
Hmm.
Actually, under NDPS Act, the mandatory period,
Hmm.
statutory period is 180 days.
Hmm.
Not yet, but I'm not on that ground.
Hmm.
I'm not on that ground.
Hmm.
I'm praying that parity, the principle of parity should be applied, 1. Number 2, why nothing was recovered from my possession?
Hmm.
Why nothing was found from my house? I was an innocent victim. So therefore, I have come before this under 439 CRPC.
Let us see the case diary then. Yes. Hmm. Go. Let us see the case diary.
Okay.
Beyond that, anything?
No, if lordship want to peruse the case diary, then I can't.
Unless, because have you annexed the bail rejection order also?
No, not required, because this is not appeal, my lord. I have stated the facts.
Because the grounds, on the same ground, how do we reappreciate?
My lord, this is not appeal. This is bail.
Hmm. Subsequent bail, but then subsequent bail also, unless the situation has changed, it will be difficult on the same ground.
See, the court will speak.
Hmm.
The bail was rejected only on medical ground, that it is not serious. parity principle was not taken, the innocency was not considered.
Is it a serious case? The spinal one?
Lordship, I'll show. Lordship, page 19, last page 19, this is the official. But this is not very readable. I have typed out page 20.
This is, yes, because it's connected with the spinal
Yes,
backbone.
yes. So therefore, if
Call
Lordship
for
see,
case diary, let us see.
my lord,
Call for case diary, let us see.
sure, sure.
If the case has not yet been charge sheeted. Okay. Mr. Azo, not counsel for the petitioner. I've also heard Mr. Angami, Nana PP. This is a subsequent bail application under section 439 CRPC. Filed by the petitioner praying for release of the accused, Mrs. S. Nasu, on bail, who has been arrested by which police you said?
Narcotics cell, state narcotics cell,
State narcotics cell
my lord.
in connection with the narcotic police case number 0224 under section 21 C
C.
of the NDPS Act.
Correct.
1985. Start. Issue notice. So this is which case? Where it is?
My lord,
3 weeks. Returnable by 2 weeks.
my lord, coming days, High Court is on holiday this week.
Okay, before holiday, you want?
This High Court is on holiday from 23 onwards.
Oh, thereafter only?
Yes.
Hmm.
So till 26.
Okay, next week?
Lordship, if it can be on 3rd,
On third?
because
Okay,
the next week I'm in out of station, I'm in Tuinsang
okay.
for one criminal case.
Returnable by 3rd June. Since Mr. No, call for the case diary. Yes, sir. Scan copy of the case diary, huh? Scan copy, huh? Start. Huh? Since Mr. Angami accepted notice on behalf of the state, I appear on behalf of the state, no formal notice need be issued to the respondent. Start. Huh? So you produce case diary and an option instruction also?
Lordship.
Because it appears that there is some medical document he has annexed. Okay, list this matter on 3rd June. Okay.
June. Majulai.
Yes,
For motion, item numbers 25 and 26.
May I please, Lordship?
yes.
Lordship, the petitioners have filed a criminal petition under 482 for quashing setting aside of the criminal posting for the learned court at the court below, Lordship. But is it? Lordship, as such, this honorable court, perusing the petition filed by the petitioners,
Yes.
passed the order dated 6/6/2019.
Hmm.
That is at page 9, Lordship. The relevant portion is page 9 of
Yes.
IA. The case of the petitioner is that the learned court below, without following the procedures of 202 CRPC, has issued notice upon the petitioners but the petitioners are not residents of under the jurisdiction of the Honorable Court below, but they are residents of another state, which is Hyderabad, Lordship. So, Lordship, this Honorable Court on 6/6/2019, Lordship, the interim order. Lordship may come to
19.
yes, Lordship. Lordship may come to page 9 of my IA. I have annexed the order. Page 9 of the IA, Lordship.
9.
Page 9.
Yes, what is that?
Lordship, I may be allowed to read, Lordship.
Hmm.
Heard Mr. So-and-so, Learned Counsel for Petitions, and Mr. So-and-so for the PP for the state. By this application under section 482 CRPC, the petitioners have prayed for quashing of the CR case number so-and-so, pending before the court of the Learned CGM Longland, Nagaland, as well as the order dated 21/5/2019 and the issuance of summons pursuant to the state order. It is projected that by the order dated 21/5/2019, the Learned CGM Longland has issued process against the petitioner under section 406, 417, and 420 IPC taking cognizance of the complaint. The Learned Counsel for Petitions have submitted that all the respondents are residing outside the territorial jurisdiction of this court. However, the Learned Court below had failed to follow the provisions of section 202 CRPC. They submitted that the issuance of process was required to be postponed, and it was mandated that the court taking cognizance should either inquire into the case himself or herself, or direct the investigation to be made by the police officer or by such other persons as the court may deem fit for the purpose of deciding whether or not there is any sufficient ground for proceedings. The Learned Counsel for the petitioners have referred to the order dated 12/4/19 to project that the Learned Court below had recorded the statement of the complainant on oath under section 200 CRPC and had followed on his satisfaction after making inquiry under 202 CRPC had allowed registration of this criminal complaint petition. The Learned Counsel for Petition has produced an order of the order dated 21/5/19, wherein it is reflected that 5 witnesses were examined on the day, and it is submitted that the Learned Trial Court having already issued process on 12/4/19, the examination of the further witness of 21/5/2019 was not tenable in the eyes of law. In view of the said projection made by the Learned Counsel for the petitioners, this court is inclined to issue notice returnable on so-and-so. The petitioners shall take steps for service upon respondent 2 by registered post AD by tomorrow. Till the next returnable date, the further processing of CR case number 1 of 2019 pending before the court of the Learned CGM Longland shall remain stay. The petitioners shall file so-and-so. So, Lordship, on this day, on 6/6/2019, this Honorable Court was pleased on hearing the petitioner to stay the proceedings below of so-and-so. And Lordship, at page 12, the interim was continued.
Whether record was called for,
Lordship,
whether the record.
yes, Lordship, record had been called for.
It was the original record was called for.
Lordship, I believe it's with the, in fact.
What is the status of the trial? Trial proceeded thereafter?
No, Lordship, the state. After this order, telling state. But Lordship, on 21/4/2022, when this Honorable Court, that is at page 15, Lordship may come to page 15. Page 15, relevant portion is at page 15, Lordship.
Yes. Continue till?
The interim was continued till the last date prior to this date, that is 21/4/2022.
And
On this date, Lordship, I may be allowed to read the parties are represented by the representative council. It is also seen that the LC has come. Office to prepare paper book at the cost of the appellant and list the matter once the same is ready and copy is served to the rival parties. No interim was passed in this date, Lordship.
This is criminal petition
Yes, Lordship. Immediately fine,
for setting aside only. Washing.
Lordship. Washing, Lordship.
The paper book was prepared.
Prepared, Lordship. So, Lordship, on this day, that is on 21/4/2022, the petitioner has paid for continuation of the interim, but inadvertently, no record.
Deliberately, probably deliberately.
No, Lordship.
Continued.
No, Lordship. Lordship. So, Lordship,
Hmm.
paper book is prepared, and Lordship may come to the order, Lordship, at page 17 of the IA,
Hmm.
Lordship here, relevant portion is at the type copy is at page 19, Lordship.
What is this?
The complainant, that is responsible too. The complainant has,
No, this is the impugned order or what?
no, Lordship, that is the order passed on 14 to
Okay,
24,
okay. So,
issuing summons against the petitioners by the learned CGM Longland, Lordship,
yes,
relying on the judgment of the Asian Resurfacing of Road Agency Private Limited versus CBI in 2018, 6 SCC 299. But Lordship, on the next date, that is on 10/4/2024, Lordship.
no, what is this? What is this order you want to show?
Lordship, this order is summoning the petitioners. Since the council for the Lordship may come to the second paragraph of the order dated 14/2/2024. Page 19, Lordship.
Yeah,
Page 19.
19?
Second paragraph, Lordship. The learned counsel submitted that the accused who are the petitioners of the Honorable Gauhati High Court Kohima bench number so and so, there is a criminal petition
You are reading
519.
which page?
19.
This is different from the one which I have seen in page 17.
That's Lordship.
Is it the same?
That is the same.
That copy.
19 is the type copy, Lordship.
Okay,
Seems not very clear.
yes.
So at paragraph 2, the learned counsel submitted that the accused who are the petitioners of the Honorable Gauhati High Court Kohima bench, case number criminal petition 5 of 2019 has failed to pursue the matter in the High Court. Hence, the case has been pending without any progress. He therefore argued that the Honorable High Court stay on the proceedings should be vacated as the matter pending in the Honorable High Court was last taken up on 21/4/2022, and that no extension order on the stay was passed in that order. Hence, he argued the issue summons upon the accused, reliance was placed upon the Honorable Apex Court judgment in Asia Resurfacing of Road Agency Private Limited versus CBI in this case 890 of 2021 to substantiate his case. Lordship, relying on this, the complainant, there is a respondent 2.
What is this?
Lordship, there is a paragraph 3. In view of the above, the situation of proceedings remaining pending for long on account of stay needs to be remedied. Remedy is required not only for corruption cases, but for all civil and criminal cases where on account of stay, civil and criminal proceedings are held up. At times, proceedings are adjourned sine die on account of stay. Even after stay is vacated, intimation is not received and proceedings are not taken up. In an attempt to remedy this situation, we consider it appropriate to direct that all proceedings where stay against proceedings of a civil or criminal trial is operating, the same will come to an end on expiry of 6 months from today, unless in an exceptional case by speaking order, such stay is extended. In cases where stay is granted in future, the same will end on expiry of 6 months from the date of such order, must show that the case was of such exceptional nature that continuing the stay was more important than having the trial finalized. The trial court, where order of stay of civil or criminal proceeding produced, may fix date not beyond 6 months of the order of stay, so that an expiry of the period of stay proceedings can commence unless order of extension of stay is produced.
Yes.
Or I may be allowed to read. As per the documents placed before on record, a stay order was passed on 6/6/19 by the Honorable Gauhati High Court Kohima bench, and therefore on 39/3/19 there was an extension of stay orders. Since then, no extension of the stay order was made. Hence, it has been more than 6 months since the last stay. Supra, the trial of the case shall proceed as per the proceedings established by law. Since the case was at the stage of issue of process, issue summons upon the accused, fixing on 14/3/24 for appearance of the accused. But Lordship,
Yes,
on that is at page 20, or should become the page 20, Lordship.
yes,
Order is dated 10/4/2024. Complainant is absent with steps and represented by proxy counsel Chiang Mai. Accused are absent. However, they are represented by their learned counsel K. Michael Lucan. Learned counsel so vehemently argued that the complainant has misled the court by pursuing the court to issue process upon the accused despite a stay on the proceedings by the Honorable High Court. They further argued that since the Honorable Apex Court judgment Asia Resurfacing of Road Agency Private Limited and another versus CBI in misapplication 890 of 2001 was under challenge, the court could not have relied on judgment to issue summons upon the accused, and there was a stay on the proceedings. He then stated that the Asia so and so has been overruled by the High Court, Bar Association versus State of UP and others in Manu SC 0149/2024. Hence, he vehemently argued to revoke the court order on or keep the matter in abeyance since there was stay of proceedings in the trial of this case. Learned proxy counsel argued that despite service of summon, the accused failed to appear before the Honorable Court. Hence, it was argued that the accused should be made to present before this court. I have heard the submissions made by the learned counsel and perused the documents on record. When the order issuing summons was passed, that is on 14/4/2020, Asia Resurfacing of Road Agency versus Supra was the precedent, even if it was under challenge in the Supreme Court. Hence, the argument of the learned counsel stating that the court could not have relied on the judgment does not hold water. However, considering the change in the law by the President of the High Court Bar Association Supra, an opportunity is hereby given to the defendant to obtain an extension of the existing stay order and thereafter present it before this court on or before the next date fixed for hearing, and the summons issued upon the issue accused is hereby recalled. The order dated 14/2/24 was recalled, Lordship. And Lordship, this Honorable Court the Honorable Court below on 10/4/2024 has fixed the matter on 9/5/2024. I may be allowed to place an order, Lordship.
yes.
On 9/5/2024,
Yes.
on 9/5/2024,
Mm.
the complainant is absent without steps and remain unrepresented. Accused are absent. However, they are represented by the learned counsel so and so. The learned counsel submitted that due to some personal difficulties, he could not file the compliance order as directed by this Honorable Court in order dated 10/4/2024. Hence, he paid for some time to file the same. Therefore, an opportunity is given to the accused to positively file a compliance report on or before the next date fixed for hearing. Fixed on 12/6/2024 for compliance report of the defense and necessary orders. Your Lordship,
So,
the learned counsel arguing before the learned CGM Longland is placed in the citation of this honorable apex court. Lordship, I will be allowed to place the judgment of the High Court Bar Association.
just a minute.
Versus-
There was a private respondent. Just a minute. Yes, Miss Mary?
I've just received a copy just now only. So on parcel, Your Lordship, there is a lapse of 2 years, Your Lordship.
Yes,
Petitioner should have attempted,
that is right.
yes, since
And thereafter it was
2022.
taken up before the trial court also.
Yes.
Anyway, but.
Lordship, the lapse was not on the, not,
Why it was not listed?
Because
Long period.
for preparation of paper book, Lordship. Lordship may see the last order, Lordship.
Paper book, whether paper book was required, this case, there was no.
This honorable court,
Then case, yes, your lordship.
in the main case, Lordship, this honorable court on 21/4/2022 has directed to prepare paper book, Lordship. Lordship may see page 15 of my IA, Lordship. The order is very clear. Page 15 of the IA.
Yes,
On this date, Lordship,
yes.
parties are represented by the representative council. It is seen that the LCR has come. Office to prepare paper book at the cost of the appellant and list the matter once the same is ready and copy is served to the rival parties, Lordship.
You have any objection, Ms. Mary?
Lordship, I may be allowed to.
Your lordship. I'll leave it to your lordship.
Private respondent is also there.
Yes,
Lord,
yes, your
sharing,
lordship.
no.
Yes, yes, your lordship.
Let the private respondent also appear.
Lordship,
Because there, it appears that the private respondent, they have also pursued before the line of trial
Trial
court.
court. Yes, yes.
yes,
Otherwise,
even otherwise, Lordship,
order can also,
I may be allowed to place this judgment,
hmm,
this authority of the Supreme Court,
hmm.
passed in High Court Bar Association, Allahabad versus State of UP and others.
What is this? What it says?
It's regarding the extension of interim orders, Lordship.
Okay. Then what it says finally?
Relevant portion is at the para 34-35.
Yes.
Para 34 and 35. Lordship. Para 34, 35, 37 and 41, 47. Those are the relevant paragraphs. I may be allowed to read.
So, what we will do is, since there is also private respondent and it has come up.
Yes, Lordship, but
Let-
Lord,
Serve copy to the private respondent, with no objection will extend. Yes.
no, Lordship, this honorable court,
Hmm.
this honorable court on 6/6/2019,
Hmm.
without hearing the private respondent, has stayed the proceedings, Lordship. So my only prayer is to extend the interim order passed on 6/6/2019.
6/6/12/19.
That is at page 9, Lordship. Page 9. Page 9. This honorable court on 6/6/2019,
Hmm.
without hearing the private respondents, have stayed the criminal proceedings. Because the learned
Now,
PGM,
this
the court below,
This was still returnable date only.
Lordship, and that was extended. But on 21/4/2022, while this honorable court has given direction to prepare a paper book, even on the prayer of the petitioner, inadvertently, the order of extending the interim was not continued. So today, the petitioners are before this honorable court,
That's
praying
what I'm
to
saying,
extend the
maybe-
petition, the interim order passed by this honorable court on 6/6/2019, Lordship. But this honorable court can extend, Lordship,
Because
the
there are,
the interim order 6/6/2019. And even Lordship, the court below has given opportunity to to get the extension order from this honorable court, Lordship.
see, this was
Because-
only till the returnable date.
Yes, Lordship. But Lordship, the case of the petitioner is that.
Hmm.
The case of the petitioner, Lordship,
In presence of the respondent, we'll have a hearing on this.
Lordship, let not.
my humble prayer, Lordship,
Hmm.
is the case of the petitioner is that the honorable court below, the CGM,
Hmm.
Longland, without taking in the process of 202, has issued notice upon respondents, which is not tenable in the eye of the law, Lordship. That is why the proceedings of
In
Any proceeding has been
any
stayed.
case, the.
so even otherwise,
Hmm.
without hearing the private respondent, this honorable court has the jurisdiction to stay the proceeding, Lordship. My prayer is only that, Lordship. Since this honorable court has stayed the proceeding, that the court below, without going through the process of 202, has issued notice upon the someone upon the petitioners under 200, section 200 of the CRPC, Lordship. That is the case, Lordship, of before this Honorable Court, Lordship. So this Honorable Court has the power and the jurisdiction to stay the proceedings even now, Lordship, even after a gap, Lordship. Since the Honorable Court on 6/6/2019 has rightly stayed the criminal
No, that
complaint below.
was still returnable date, I'm saying.
Lordship,
So
and even after that,
indicating that the stay will be passed, the order of the stay will be passed after hearing the parties.
Lordship, so Lordship may come to page 12. Even on 31/30/2022 till 31/3/2022, this Honorable Court has been extending the interim order on the prayer of the Learned Council, Lordship. For the petitioners.
By then also probably the private respondent did not appear.
No, Lordship, they were appearing, Lordship.
They appeared. Okay. Anyway, so let him appear.
So my humble prayer is, Lordship, this Honorable Court has a jurisdiction to continue the interim order passed by this Honorable Court on 6/6/2019, Lordship, without even hearing the parties, Lordship. Because the process.
Mr. Posego Porte, Learned Counsel for the applicant. I've also heard Ms. Mere, Learned PP. Stop.
If Lordship may kindly allow me to go through the, allow me to present the authority passed by the Supreme Court, Lordship.
Yes.
Lordship, I may be given the English, Lordship.
You obtain instruction, what is the status there in the trial court? Why? Because thereafter the record probably is here, the original record. How or why it was proceeded there? On what basis? We obtain instruction. So after hearing the parties, the order will be
Lordship,
passed. Otherwise, you say,
It's very clear from the order, Lordship.
yes,
Lordship may come to page 19, Lordship.
19 of
Page 19 of my IA, Lordship.
IA.
Lordship.
Yes.
The proceeding
Hmm.
before the learned CGM, Longland, has been stayed at the time of summon, Lordship. That's why since Lordship may come to the last paragraph on page 19.
Yes.
Since this case was at the stage of issue of process,
Page 19.
page 19 of my IA, Lordship.
Which paragraph you are reading?
Last paragraph. Second last paragraph, my lord.
Yes.
Since this case was at the stage of issue of process, issue summon upon the
No,
accused.
where?
Page 19, Lordship.
Yes, 19.
Second last paragraph,
Second last paragraph.
Lordship. Third line from the bottom. Third line from the bottom. Since
Okay.
this case was at the
No.
stage of issue of process, issue summons upon all the accused. This Honorable Court on 6/6/2019 state the proceedings
No, just a minute.
At the-
Page 19.
at,
I didn't get that.
at this page 19, Lordship.
19.
Page 19
Order passed by?
by the CGM, Longland, Lordship.
Okay. So,
Since this case was at the stage of issue of process, issue summon upon the accused, Lordship. The process of issuing summon upon the petitioners by the learned court below, Longland, was not taken in the process as per 202 of the CRPC, Lordship. That is the whole issue of this, the criminal petition 5/2019, Lordship.
And then thereafter what happened? It was
Lordship.
fixed.
That was on 14/2/2024.
Hmm.
And on 10/4/2024, the learned court below has given time to the petitioners to approach this on the court, the High Court, and take the extension of
So where it is?
that is at page 20, Lordship.
20, where?
Second last para.
Yes,
When the order, Lordship has got it.
yes.
When the order issuing summons was passed, that is on 14/2/2024, Asia Resurfacing of Road Agency Private Limited, Supra was the president, even if it was under challenge in the Honorable Supreme Court. Hence, the argument of the learned counsel stating that the court could not have relied on the judgment does not hold water. However, considering the change in the law by the President in High Court Bar Association, Supra, an opportunity is hereby given to the defense to obtain an extension of the existing stay order and thereafter present it before this court on or before the next date fixed for hearing, and that the summons issued upon the accused is hereby recalled. The order of 14/2/2024 was recalled, Lordship,
Hmm.
and was fixed on 9/5/2024.
And okay, this is an application after that, huh? Under section 482 CRPC for extension of the interim order passed by this court on 6/6/2019 to be continued till the next date of hearing. Para. The Honorary Counsel for the petitioner, Mr. Pacheco Corte submits that by an order dated
31/4/22. That is a page 15, Lordship.
6/6/2019. The proceeding of CR case number 01/2019 was stayed till the next returnable date. Thereafter, by an order dated 31/3/2022, the interim order was continued. However, on 21/4/2022, while passing an order for preparing of paper book, inadvertently, despite a prayer made by the land council for the petitioner, the interim order was no order was passed for continuation of the interim order. Stop. Thereafter, the Learned Trial Court, by an order dated 14/2/2024, issued summon to all the accused persons on the ground that the interim order was not continued. However, in view of the order passed, which was the in view of the judgment and order passed in the High Court Bar Association versus State of UP and others, comma, Manu stroke SC stroke 0149 stroke 2024, comma, the Learned Trial Court has given an opportunity to the petitioner to obtain extension of the stay order. Stop. The land council for the petition further submits that the original is there. Original LCR.
Yes.
Okay. The LCR is called for is before this court. And in any manner, the proceeding in the trial court that will, may not be possible in absence of the original record, as the record is before this court. Stop. In view of the above, and as the record, the LCR is also before this court. I'm of the view that the interim order passed on earlier on 6/6/2019, which was extended on 31/3/22, can be extended till the next date. This date will be fixed for?
Lordship, the main case, criminal petition 5 of 2019
Hmm?
was criminal petition 5 of 2019, the main case.
Maybe it's 18.
Oh, sorry, 18 was listed yesterday for hearing. Has been yesterday the order, this honorable court has passed an order for hearing in the legal court, Lordship.
Okay.
So in the main case also, the honorable court may, as per the order passed today in the IA.
In the next 19. Accordingly, it is ordered. Stop. With the above is IA stands disposed of. In the main, are Mr. Seko Putte, Lana counsel for the petitioner, and Ms. Mere Lana PP. Stop. Since the Lana counsel for the party submits that they have received the copy.
Lordship, I've
Received
received the paper book, Lordship.
Yes.
My lord, this, I didn't want to interrupt you, again. The same matter,
Hmm.
It was pending before the Gauhati report, before the three judges bench.
Okay.
I was arguing this matter.
Okay.
Meanwhile, the Supreme Court gave this decision. The judgment was reserved by the Supreme Court. While our matter was pending, Supreme Court gave the verdict, which you have rightly pointed out.
Supreme Court given.
Had given the verdict in Allahabad Bar Association case,
Okay.
as far as interim orders are concerned.
Yes.
And again, the matter was heard by three judges bench and judgment is reserved.
Judgment is reserved.
Judgment is reserved. I just wanted to point out, since I am in the court,
Okay.
I thought I should bring it here. That doesn't affect anybody's issue. Maybe the judgment will come up shortly. But whatever point he has raised, I had argued the point also before the three judges.
Okay. So then,
I think even if he is, but that was basically under Article 226, and the discussion was on civil matters at that time.
okay.
So that Supreme Court judgment says that you cannot just take it off. And the argument before the High Court was, when you are granting stay, you take into consideration so many factors, like prima facie case, balance of convenience, injury, etc. Just because they say within such and such time it will go away, then those principles are not applied. So that is wrong. That was our argument
Okay.
before the High Court,
Hmm.
and the Supreme Court has passed it. I thought I'd just bring it to your Lordship's notice.
But in any case, here in this case,
Yes.
probably all the records are here
Yes.
to consider. Probably whether records were necessary or not, because this was not a disposed case. It was in the initial stage of the trial.
Initial state, Lordship.
So the record was called, and then the record, not a scan copy, but the entire original copy received, and then paper.
I'm not commenting at all on the
Hmm.
case.
Okay.
I thought
Okay.
whatever I
Thank
saw,
you,
I should,
thank you.
I was just thinking whether I should tell or
Right.
not.
Thank you.
Because I was present, I thought I'd just inform.
So we'll try to expedite disposing of the matter, entire matter. Hmm. In view of the order passed in the IA. The interim order dated passed earlier. On 6/6/19 and extended when it was extended to, last extended,
Lordship last extended on 31st March 2022.
mm,
That is at page,
interim order passed earlier shall continue till the next date.
Lordship.
And since the matter is ready for hearing, let's list this matter for hearing after 3 weeks.
Lordship.
Okay.
Highly obliged.
Hearing what, then, okay.
For motion item number 27.
Yes,
My lord, since there is some defect in the petition, I may be allowed to withdraw.
this is against the Jimma, rejection of the Jimma petition.
Please, Your Honor.
Jimma, okay,
Yes, my lord.
Mr. Parkin Richard Bo, no?
Yes, my lord.
Land counsel for the petitioner. Some said there is some error in the petition and praise for allowing him to withdraw with the liberty. You want to file again or just want to withdraw?
I'm going to change the petitioner.
Hmm?
I have to change the petitioner, my lord, since the registered owner has expired. So
Who is it
previously,
expired?
the owner of the vehicle, the registered owner of the vehicle
Okay,
have expired.
okay.
And
In the post title, is the post title, huh? Is the registered owner of the vehicle expired during this
Yes, my
period?
lord. Before the offense, the registered owner have expired.
Okay, there's some mistake, huh, in the course title with regards to the name of the parties and praise for allowing him to withdraw the same with liberty to file again. This case is, this is on being withdrawn with liberty is prayed for. Okay.
For motion item numbers 28 and 29.
May I please, your lordship?
Yes,
Lordship, this instant IA is filed praying for implement of the new incumbent officer, lordship, the commissioner as a respondent number 6 in COP 2 of 24, lordship.
Miss Mika, Land counsel for the applicant. Stop, and this is an application seeking leave of this court to
Lordship, at page number 4, serial number 6, lordship.
implement. The Land counsel for the petitioner submits that during the pendency of this, with the contempt petition, the respondent number 2, Sri P. Mabeno Yanthan, the commissioner Nagaland Kohima has been transferred, and in his place, new incumbent one Sri Sushil Kumar Patel, IS, has been posted. And pray for implement of the new incumbent in place of the new incumbent as a party respondents. in the contempt petition number 10, 2024. Stop. Who is for the response now? You're for.
Lordship, we cannot object nor allow
Yes.
Lordship because we don't have a copy of the application.
Okay, sir. Okay, Mr. Okay. Who is for the respondent number 1, 2? You are for?
Yes, Lordship, I am for 1, 3, and 4.
Mr. Gamila, council for the respondent number 1, 3, and 4. And
for
Mr.
respondent number 5.
Not 2, Lordship, 1, 3, and 4.
1, 3, and 4. Oh, okay. And Mr. His name, Planning Council for the respondent number 4, 5 are also present. Stop. So this is a respondent number 2.
Lordship.
Okay. You are representing 1, 3, and 4.
Yes.
Not the 2. Who represent 2?
No one, Lordship.
No one
He's
represents.
yet to be represented, Lordship.
Okay. This was in the initial stage.
Lordship, in fact, we took Dusty. We have already issued a notice. However, he did not appear. So on the next day, we took Dusty survey. So when we served the copy, we were informed that he has been transferred. So,
Okay.
Lordship.
Then before that, no. So since the respondent is a necessary party, since Mr. So and so, Sushil Kumar Patel, the present incumbent is a necessary party, the prayer is allowed. The petitioner shall file amended course title by including the new incumbent as respondent number
6, Lordship.
This will be 6.
Lordship.
As respondent number 6. Okay, and they are present. You take a step also
Lordship.
in the main. Okay. Then this disposal. With the above, this I stands disposal. And in the main, in view of the photo pass in the IA, the Mr. What is his name?
Sushil.
Sri
Sushil Kumar Patel. Yes.
IA has been included is respondent number 6. The petitioner shall file the amended course title, including the said respondent. The petitioner shall also take steps upon the newly implemented respondent number 6 by a registered post with AD within a week from today. Starting. This is matter after
2 weeks, Lordship.
2.
Lordship. Yes, Lordship.
Okay.
Much obliged.
For motion item numbers 30 and 31.
Please, Your Lordship.
Yes.
Here to present, I have a similar appeal, Your Lordship, to this for implement of respondent number 4 as party respondent, Your Lordship. That is the principal director of treasuries and accounts. Since the earlier respondent is respondent number 3, he's been retired. So it's become a necessary party for implement of respondent number 4, Your Lordship.
The
Relevant page is para 7 of my application, Your Honor. Page 7 of my application. Relevant para is para 2 and 3.
Okay. Mr. Supamati Walling, Land Council for the applicant. This is an application for implement of Srimati Wahani Tissa, the principal Directorate of Treasuries and Account, Nagaland, as respondent number 4. Stop. The Land Council for the petitioner submits that during the pendency of this the contempt petition number 23, 2023. The respondent number 3, Sri R.N. Yanthan, who was the principal director, Directorate of Treasuries and Accounts, Nagaland, Kohima, retired from his service. And in his place, new incumbent, Srimati Vahani Fisa has been posted and posted. And pray for allowing him to impeach the new incumbent as respondent number 4.
Yes, Lord.
Okay, stop. You are appearing?
Your Lordship, and for respondent number 3.
Okay, the prayer is, since the new incumbent is a necessary party, the prayer is allowed. The petitioner shall file amended post title by including the newly incumbent Miss Srimati Vahani Sisa as respondent number 4. Stop. Miss,
Alitos.
you are for respondent number
3.
and you are for respondent
Number 1 and
2. Okay, Mr. Zimomi. Appear on the Zimomi for respondent number 1 and 2. 1 and 2. And Miss
Alitos.
for respondent number 3 are also present. Stop. With the above this, I stands allowed and disposed of. And in the main, in view, hard all them.
Your Lordship, in the main petition, I'm allowed to take steps, Your Lordship, to restore it.
Mr. Supamati also had the vote. Mr. Jimomi for respondent number 2, 1 and 2, and Ms. Swanjan for respondent number 3 are present. 3, stop. In view of the order passed in the IA, the Ms. Srimati Swanson is included as respondent number 4. The petitioner shall file amended post title. Stop. And the petitioner shall also take steps upon the newly implemented respondent number 4. Step upon newly implemented respondent number 4 by a registered post with AD within a week from today. Stop.
2 days, Your Lordship.
3 days, within 3 days from today. List is matter after.
Your Lordship, on the last occasion, on 30, 14, 24, time was conducted 3 weeks time, Your Lordship. So if the matter may be listed accordingly on.
After 3 weeks. Okay.
August.
For motion item number 32.
Yes.
May it please, Lordship. Lordship, the present IA has been filed with a prayer for withdrawal of the additional affidavit which was filed on 4th of March 2023. An additional affidavit, Lordship. Why that additional affidavit I have enclosed a contract agreement, Lordship. Now after filing, Lordship, page 189 of the contract agreement, there is a typographical error, Lordship, in the contract agreement, Lordship.
Typographical error to type the contract agreement.
Yes, Lordship.
Typing.
Yes, Lordship.
Okay.
Yes, Lordship.
So the original is also there.
Yes, Lordship. Originals. But
Okay. Only the typographical mistake.
yes, Lordship.
So you want to withdraw.
And a prayer to file a fresh affidavit, Lordship, producing the latest contract, Lordship. What has happened in this case? 3 contractors were engaged on 3 different occasions for the package 4 under Mon District, Lordship. We are concerning with package 4. Now the petitioner in this petitioned. The prayer is for widening of that a stretch of road, which is for 3 kilometers, 4 kilometers, and 370 meters. In Mon Town, Lordship, there is a stretch of road
from SSB Nala to Techa Nala, Lordship. Now their contention in the prayer in the read petition is that it has to be whitened. Now, as per the contract agreement, it is stated that there is no scope for whitening, but it is for strengthening, Lordship. Now, what has happened in the contract agreement, which was executed as subsequent, the second contract agreement, it has stated that it is for whitening, Lordship, instead of strengthening. That was the year committed, Lordship. But I have also made a categorical statement that in the first contract agreement and the third agreement, it has been stated that there is no scope for whitening, Lordship. So my contention is that the second contract agreement, when it was executed, that typographical error had occasioned, which was unintentional. And the latest contract agreement, which was executed in the year 2021, Lordship, it is clearly stated there is no scope for whitening, Lordship. It is only for strengthening. So in order to appraise this honorable court with the records, Lordship, if I may be allowed to file a fresh affidavit, additional affidavit.
Affidavit was the copy of the additional affidavit you have already received.
Yes, Your Lordship, and I have an objection to the prayer made by the NHIDCL.
Yes.
So my learned brother is making a submission that there is a typographical error. Your Lordship, I disagree with that. The DPR, which is annexed with the first read petition, they have quoted one number 6035 as the stretch of road where the petitioner's land lies. And there is no specific mention, Your Lordship. Number two, Your Lordship, this read petition was filed in the month of September 2021. The contract agreement, which my learned brother is saying that there is a typographical error, this was executed on 18th of November 2021 after the read petition was filed. Have they been able to find out that there were typographical error after 3 years, Your Lordship? Such submission, Your Lordship, respectfully, my Lord, that is unacceptable. Only because there are 700 meters in the contract agreement signed on 18 November 2021, that is in the additional affidavit, Your Lordship. There is a stretch of 700 meters that is for widening as well as for strengthening and widening and maintenance, Your Lordship. What is it? Widening and strengthening, Your Lordship. Widening. So, Your Lordship, this is for 700 meters. My Lord, respectfully, my Lord, this is misleading because, as I have already stated at the course of repetition, Your Lordship, this read petition was filed in the month of September 2021. The contract agreement was executed on 18th November 2021, Your Lordship. So to realize this after more than 2 years, this is misleading, Your Lordship.
This is for
The IU is only for withdrawal of the additional affidavit.
additional affidavit.
Yes,
Not
Your Lordship.
petition.
In the additional affidavit, the contract agreement, which was not in my possession, Your Lordship, it has been annexed with this. And here in the additional affidavit, my Lord, may I take Your Lordship to the additional affidavit?
Your Lordship may kindly appreciate that in the main read petition, Lordship, I representing respondent number 6, I have also filed an affidavit, Lordship. Now I have enclosed the contract agreement which was executed in the year 2018, Lordship. And that was in operation at the time of filing the read petition, Lordship. Subsequently, I filed an additional affidavit. I've enclosed a second contract agreement, Lordship. Now there is also a third contract agreement, Lordship.
He's talking about the additional affidavit only.
Yes,
not the
Lordship.
Petition.
Yes,
No, Your Lordship. The document in the additional affidavit.
Additional affidavit in the type, it's a typographical mistake.
Yes.
Yes, Your Lordship, that's why.
Typing out the documents
Lordship.
in the
Yes, Lordship. Yes, Lordship.
No, Your Lordship.
No. it's
I am
not like-
saying that it cannot be a typographical error. The document which is annexed at the in the additional affidavit, may I take Your Lordship to page 9 of the additional affidavit filed by the respondent, NHIDCL.
It's here.
Additional affidavit in WC 194 of 2021.
Lordship, it was filed on
I
4th
can-
March, 4th March 2024, Lordship. Additional affidavit, 4th March 2024.
So you want to fight then? Just a minute. Additional affidavit.
It's a fact document. Additional. Okay. So, Your Lordship,
You want to file objection then?
I may be allowed to file an objection to this. prayer for withdrawal.
Okay, just for confirmation, let us see where the type, where is the original document to which you have typed out, original document in the additional exhibit?
Lordship will find it, the area has committed page 189 of the affidavit, which I have enclosed, Lordship, in the contract agreement, 189 of the contract agreement. Lordship.
I have received this interlocutory application copy yesterday, my lord. So kindly grant me 3 weeks' time to file a necessary objection to this prayer for withdrawal.
This is additional. Additional 89 is not, 189 is something else. Okay, you want to file objection? Let him.
Yes, Lordship, yes, Lordship.
Mr. Moazamir, Madam Counsel for the applicant. I've also heard Mr. Chakri, Lanet, Counsel for opposite party respondent, opposite party.
My lord, I'm for state respondent number 1, 3, 4, and 5.
Okay, then which name first, Mr.
LD Center.
For Lanet Counsel,
Respondent
Government
number 1,
advocate.
3, 4, and 5.
Advocate for respondent number 1, 3, 4, and 5. And Secretary Joshua for respondent number.
No, your lordship, I'm the petitioner, counsel for the petition.
I'll call someone number to visit.
Your lordship, in this IA, I'm for respondent number 7 to 48.
Okay, opposite party number 7 to 48. So, and you are for?
Respondent number 2.
Okay. Mr.
Union
for
of India.
respondent number 2, stop, Fair. This is an application seeking leave of this court to withdraw an additional affidavit filed on 4/3/2024 on behalf on so and so on behalf of the respondent number 6 in the writ petition. Writ petition is number 194
Yes, 194 to 198, Lordship.
to 198.
Of 2021, Lordship.
In 2021. To rectify an inadvertent typographical error and thereafter seeking permission to file a fresh affidavit. Staff. Mr. So, Mr. Joshua, you also want to file?
No.
No, okay. Land Council, Joshua Secretary, Land Council for the respondent, that one, huh? Praise for some, want to file objection and praise for some time. Have you received the copy?
Yes, my lord. I've
Okay.
received yesterday.
The prayer is allowed. Please this matter after
3 weeks, my lord.
3 weeks. Okay.
Lordship, this IS linked with the hearing item 19 to 23. If this.
Yes, yes, your lordship. Maybe listed together.
At least after 3 weeks, along with.
Item number 19 to 23 of the
Item
part 2 hearing item.
Okay, that is. Item number 19 is
19 to 23, Lordship.
19 to 23 is right WPC. Okay, number. Okay, along with those. Okay, this 19 to 23. Okay.
For admission, item number 6.
Yes.
So we mentioned item number 7 and 3.
Lordship, before, if I may seek your lordship's indulgence,
before item number 6, there's an order there's an item in order number 7. In order
Yes.
serial number 7, Learned AG is appearing actually. And this is this is actually ready for hearing.
Okay.
So if this can be fixed for hearing on the 17th of June.
In this case, my learned friend has pointed out
Hmm.
that one of the learned counsels, Mr. Paul, is not available.
One of the land council.
Mr. Paul,
Paul, PV Paul.
Okay. Okay.
yes, mentioned that to me.
Hmm.
In the light of that, he wants to have an adjournment.
7 and 8, item 7 and 8.
Not that because my instruction was to argue. So
Yes.
since it's a personal difficulty of.
So 6 is also connected?
No, just 7 and 8.
7 and 8, okay. 7 and 8.
Could it be on 24th, subject to your lordship's convenience?
24th June.
24th June.
Okay.
Okay. So here who is for the petitioner? So this is IA.
Yes.
And
And petition
he
filed by the
is
state.
filed by?
The state.
Okay.
This is the same case pertaining to the airport,
Okay.
Dimapur Airport. Which
Hmm. Mr. Ram AG for the state of Nagaland. I've also had Mr. Azimomi, Land Council for the
Respondents in item 7.
okay respondent. No, sole.
All the respondents.
Okay, all the respondents stuff, huh? So you want this matter to be fixed on?
24th.
Okay. Mr. Zimomi, Land Council for the respondent submits that PV Paul,
Yes, Mr. PV Paul,
PV Paul,
who is appearing in item number 8.
he was appearing as a respondent
Yes, ma'am.
in the civil revision number 224. There's some difficulties
Yes,
and prays for adjournment. Staff, comma, is prayed for by the Land Council for the parties. List this matter on 24th June, 24th June 4. Okay. The Land Council for the party submits that the matter is ready for hearing. No? Okay, list this matter as prayed for by the Land Council for the party. The matter is ready for hearing. The list is matter for hearing on 24th June. Okay.
Maybe put on the higher part of the list.
Okay, as a first item in the hearing list. Okay. Okay.
Much obliged.
You can prove from all the you can prove
Six one. Okay.
For admission, item number 6.
Yes.
May it please, my lord.
Yes.
Lordship, among jurists and legal academicians, among jurists and legal academicians, legal scholars, Lordship, they use a particular word, value judgments, Lordship. That how it's the same case, if it was decided by another judge, the judgment, the final decision could have been different, Lordship.
Final decision?
Could have been different, depending on the values of the judge, Lordship. Learned friend of mine did a research on it about 7-8 years ago, Lordship. Now, Lordship, for example, if Justice Khanna was not there in Keshavanandi Parati's case, Lordship, perhaps the minority's decision could have been majority decision and vice versa, Lordship. If Justice Krishna Iyer was not sitting in Muhammad Qiyasuddin's case, reformative justice could never have been introduced in India, Lordship. Likewise, Lordship, the values of the judge presiding over the case, Lordship, has an influence on the decision, Lordship, the personal values, Lordship. Here also, Lordship, I believe this is a fit case where the values of the judge, Lordship, both at the trial stage and before this honorable court, Lordship, can have an imprint on the final decision of the court, Lordship. Now, Lordship, coming to the facts of the case, Lordship. The fateful incident happened on the night of 18th November 2023. That is last November, last year, Lordship.
Let us assume who you are for the petitioner
Yes, my lord.
and the others are also present.
Yes, my lord, present.
You're for the respondent. And okay, this is nothing to do with in the office note. There is a office note. Reply affidavit not filed. Who was to file reply? I think.
Lordship,
hope
I wanted to file reply, but
Okay, yes.
I won't be filing, Lordship.
Okay, you
Because
won't
since
file
the
now.
LCR is here, I
Okay.
believe the records should be
So
sufficient.
call for record.
Yes,
Record is also there.
records have been called for, Lordship, on
Oh,
the on
Today
earlier
is
date.
listed for admission.
Yes, my lord.
Okay. Yes, yes, let us see what is the matter.
If the report is has not received. Let me check. Reports have been called for.
Please take a seat.
By order dated 2/4/2024, Lordship. Records have been called for. By order dated.
Is it there?
Record is there. Yes. Record was called for. Record is there. This is original, not the scanned copy. Yes.
Now, Lordship, the facts of the case is that, Lordship, it happened, the incident happened on the night of 18th November 2023. And on the night of 18th November 2023 and the early morning hours of 19th November 2023, Lordship. Now, Lordship, this is regarding cancellation of bail, Lordship, my criminal petition, Lordship.
Yes.
The petitioner's younger brother, who is already late, he died, Lordship, on 1st of December last year. He, along with his two friends and their driver, they went to a karaoke restaurant. Karaoke, Lordship, is a place where people sing, Lordship.
Yes.
Like Miri.
Yes.
At Nagarjan Junction, Dimapur, Lordship.
Okay.
Now, in the karaoke restaurant, inside the karaoke restaurant, there are tables, several tables, Lordship, where interested people may sit and sing, Lordship. So, while they were sitting, Lordship, and their driver was waiting outside in the car, Lordship. The deceased and his two friends entered the karaoke center. After that, their driver was waiting in the car, kept waiting in the car outside, near the restaurant, Lordship. Now, while they were singing peacefully, Lordship, somebody from across the table, respondents 2, 3, and 4, they were also in another table, Lordship. So, maybe some dispute arose, Lordship. Some verbal exchanges arose regarding as to which song to be sung. All of them wanted to sing their own songs of preference. So, the initial verbal exchange, it was resolved, Lordship. Again, after some time, Lordship, as the deceased and his friends, Lordship, were to leave the restaurant, Lordship, one of the accused, one of respondents 2, 3, and 4, Lordship, they challenged those 3 persons for a fist fight. A fist fight, Lordship. some boxing match,
Okay,
kickboxing match, Lordship.
okay, they were known to each other.
They were not known to each other, Lordship.
Okay,
Now, the deceased, Lordship, he tried to pacify his friends as well as those persons from another table, Lordship. That is respondents 2, 3, and 4, Lordship. But everyone did not, nobody, in fact, heeded to his advice. Nobody listened to him. So he decided to go home and came out of the restaurant, Lordship, and went towards his car. Now, yes, the deceased. At that relevant point of time, Lordship, the pool, there's a pool zone, Lordship, just next to the karaoke restaurant, Lordship. So 3 friends of respondents 2, 3, and 4, that is respondents 4, 5, and 6, Lordship. 5, 6, and 7, I think, Lordship. They came out of the pool zone, Lordship. They were playing billiards, Lordship, pool, Lordship, snooker.
they were in a different location.
Yes, yes. Next to the karaoke restaurant, Lordship. So those 3 persons came out. And out of those 3 persons, Lordship, 2 persons, that is respondents 5 and 6, they began to beat the deceased. They hit him on their head, on his body. He fell down. Even after falling down, Lordship, they continued to beat him, Lordship. Now, one of his friends, there were 2 friends, Lordship. He also came to, on seeing that the respondents 5 and 6 were beating the deceased, he also came to help his friend. Again, that person also, he also received some beating, Lordship. After
Some
that,
altercation was with 2, 3, and 4.
Yes.
Inside the hotel.
Initial alteration was with
these only, and this is the stranger.
Yes, they are not strange. In fact, all of them are stranger to the deceased and his friends, Lordship. But respondents 2, 3, and 4, and respondents 4, 5, and 6, they are known to each other.
Okay.
So, which is why when respondents 2, 3, and 4 began the scuffle, Lordship, began the fight, Lordship.
Okay.
The respondents 5, 6, and 7 also came to help, Lordship. Their friend.
Okay.
Since they were known to each other.
Okay.
It was a case of a friend helping another friend in need. Now, while this beating and fist fighting was going on, Lordship, the respondent number 3, he brought a vehicle, Maruti Alto, Lordship, one small car. And all the accused persons, that is respondents 2 to 7, Lordship, they sat in the car and then they removed themselves from the place of occurrence, Lordship.
Remove?
They went away, Lordship.
Okay.
In the Maruti vehicle.
Okay.
And they, leaving the deceased and his friends, who were all beaten black and blue, they left in the Maruti Alto vehicle, Lordship. Now, after this, Lordship, they immediately went to the police station and filed FIR, Lordship, before the officer in charge, East Police Station, Dimapur. Now, after this, Lordship, on the insistence of his 2 friends, Lordship, the deceased, he was taken to Government Civil Hospital, Dimapur, Lordship. But on seeing the condition, the hospital staff at Government Civil Hospital, Dimapur, they refused to admit the deceased, saying that this may be a police case and we don't want to look after this kind of patients. So they went to a private hospital. And all this time, the disease was bleeding, Lordship. And he was admitted at Olive Hospital, Lordship, on the morning of 19/11/2023. That is, the incident happened on the night of 18 November, and the very next morning, Lordship, he was admitted. On medical examination, Lordship, it was found that both his jaw bones, that is ramus of the mandible in technical terms, Lordship, it was broken, both sides. So he could not chew, he could not eat, and blood continued to bleed from it continuously, Lordship. But Lordship, there in that particular private hospital, there was no medical expert, Lordship, a specialist maybe, to look after such cases. And the deceased was also himself was also not very satisfied with the kind of treatment that he was receiving, Lordship. So he decided to discharge, and with the intention to go for further treatment to Gauhati, Lordship. So on 22nd of November, Lordship, the deceased, Lordship, he was discharged. And in the discharge certificate, Lordship, I don't know for what reasons, Lordship, but it is reflected as if he is a fit person, Lordship. Maybe because it was in the norms of the hospital that only a fit person shall be discharged or something like that, and without any reference being made, Lordship. Now, Lordship, during all this time, Lordship, he was bedridden at home. He was receiving treatment at home, Lordship. Now, meanwhile, the police summoned the FIR complainant, Lordship, and the accused persons to the police station on 27th of November. And Lordship, a compromise was arranged. And the accused himself, Lordship, in the compromise, while he was alive, the deceased himself, Lordship, he has stated that, Lordship, he forgives the incident that had happened and all those, Lordship. And it is also provided that the medical expenses shall be covered by the accused persons, Lordship. Now, the deceased and his family, Lordship, had decided to go for further treatment to Gauhati, Lordship, and booked flight tickets on 29th of November 2023. I've also annexed the flight tickets, Lordship. However, Lordship, unfortunately, on 28th, the condition of the disease became worse. So he was again rushed to the Olive Hospital, from which he was discharged on 22nd of November 2023 and readmitted on 28th again, Lordship, 2023. Lordship, and then Lordship, he was referred, Lordship, to another hospital within Timapur only, Lordship. And that is one Christian CIHSR, Lordship, another private clinic, Lordship, on 29th of November, Lordship. Now, all this while, Lordship, in the first hospital also, he received 11 units of blood. In the second hospital also, likewise, Lordship, 5 or 6 units of blood. He was bleeding profusely, Lordship, all this while. Now, on first, and because of his deteriorating health condition, despite him and his family having booked the flight tickets to travel to Gauhati on 29th, he could not travel. He was in no condition to travel. And on 1st of December, Lordship, he succumbed to his injuries. Now, Lordship, in the death certificate, the cause of death has been, which I have annexed at Annex 24. What the primary cause? The primary cause at page 74, Lordship. This is important, Lordship.
Page 74 is
the death cause of
Cause
death
of death.
certificate. Yes, cause
Yes.
of death certificate. Yes, issued by the medical superintendent, Christian Institute of Health Sciences and Research, dated 1/12/2023, Lordship. The primary cause is hypovolemic shock. The secondary cause is upper GI bleed and decompensated chronic liver disease. In layman's term, Lordship, this hypovolemic shock, Lordship, it occurs is an emergency condition in which severe blood or other fluid loss makes the heart unable to pump enough blood to the body. This type of shock can cause many organs to stop working. And the other is GI bleeding is a sign of disorder in the digestive tract where blood often shows up in the stool or vomit. Stool may look black or tarry. Bleeding can range from mild to severe and can be life-threatening.
you are reading which paragraph?
Paragraph 7 of my petition, Lordship, page 15. I am not saying that I'm a medical expert, Lordship, but to the best of my information, Lordship, page 15.
Yes. Yes. Yes.
Now, Lordship, after the deceased expired, the present petitioner was anticipating, Lordship, that the police will take prompt action in arresting the accused persons because FIR had already been filed on the night of the incident, Lordship. But nothing happened, Lordship. So I made an application before the Commissioner of Police, Lordship, who is in the rank of SP, I think, Lordship, as per the scheme work of the Criminal Procedure Code, on 4th of December, Lordship. And then only, Lordship, only after that, the police swung into action and the IO, one UPSI, Pangkatang C. Kitan was appointed, Lordship, for investigation. Now, Lordship, on 5th of December, anticipatory bail application was moved, Lordship.
Okay, so till the deceased died, police has not yet registered,
No, Lordship.
not yet,
No, Lordship.
although the FIR was filed on 18.
Yes, no, 19th, Lordship. 19th. That is the early morning of 19th
Okay,
November.
it was not registered.
No, Lordship. Only GT number was given. General diary entry number was given, Lordship, and then the FIR was not registered, Lordship. Now, only when an application was made before the Commissioner of Police, Dimapur, on 4th of December 2023, Lordship, the police swung into action, Lordship, and the IO was appointed. Now, Lordship, interestingly, Lordship, the very next day, Lordship, I believe the accused persons received the information that application has already been made before the Commissioner of Police, Dimapur, and they moved an anticipatory bail application before the District and Sessions Judge Dimapur, which was granted, Lordship.
On which date?
5th of December 2023, 5/12/2023.
Anticipatory bail granted.
Yes, Lordship. Now, after a week, Lordship, that is on 12th of December 2023, the interim bail, Lordship, that is interim anticipatory bail, which was granted on 5th, it was cancelled, Lordship, and they were taken into custody.
Yes.
Now, Lordship, this, I believe, is a important clarification to be made, Lordship, which I have stated at paragraph 9, page 17, Lordship.
What is
the
that?
top portion, Lordship. 2 GT numbers have been given, Lordship, in the instant case.
Two
GT general diary entry numbers. Yes.
One when FIR was lodged.
Yes, Lordship.
And the another?
When the application was made before the Commissioner of Police on 4th of December, Lordship. 4th of December 2023.
Okay.
Which is why, despite the case being in the same police station, Lordship, that is East PS Dimapur, one GT is registered 11, GT number 11, 2023, dated 18/11/2023, and another GT is registered as GT number 14/2023, dated 4/12/2023. In order not to have any confusion, Lordship, I am bringing out this fact, Lordship, stating this fact before this court. Now, Lordship, from here, Lordship, the things become interesting, Lordship. When the
anticipatory bail was granted to the accused.
Yes, to the accused, and it was cancelled on 12th, and they were taken under custody, Lordship. So from 12th December,
anticipatory bail was granted on 5th.
Yes, Lordship, on 5th.
And it was cancelled on
12th.
12/12/23.
Yes, Lordship. Now, since they were under
Anticipated bail was granted on the date of filing of the bail.
Yes, Lordship,
Okay. Cancel.
on 12th.
So this anticipatory bail was granted only after the date of the
Yes, Lordship.
deceased.
Yes, Lordship. Lordship is
By which court?
by the District and Sessions Judge Dimapur.
Okay, so it was cancelled on 12/12.
Yes, Lordship.
Who filed cancellation order, cancellation petition?
It was an ad interim anticipatory bail.
Oh, it was ad interim.
Yes,
Okay.
Lordship.
So then it was
It
was
was
not
ended
continued.
It was
Bail cancelled.
Yes,
Okay.
Lordship. Yes.
Bail cancelled. Okay.
Yes, Lordship. Without any application, Lordship, after going through the records, I believe the trial judge deemed it fit to be cancelled, Lordship. Now, Lordship, when they were under custody, Lordship, now since the option of 438 no longer existed, since they were already in custody, they filed bail application under 439, Lordship. Now, this bail application was heard on 22nd of December, Lordship, 2023.
This is second.
Yes, Lordship. 22nd.
This is for regular bail.
Yes, for regular bail, Lordship. At this stage, they were already under custody, Lordship. So on 22nd, Lordship.
They were arrested on?
On 12th of December.
Okay.
So after about 10 days, Lordship, bail was heard, Lordship. Now, Lordship, this I have annexed 28. Page 82, my lord.
Yes.
If my lord can kindly go to paragraph 5, Lordship. This is the operative portion.
Yes. Paragraph 5.
Yes, Lordship.
Yes.
I have considered the above rival submissions advanced by the learned counsel for the parties. As submitted by the learned counsel for the petitioner, Sri so-and-so, the medical records prima facie shows that the incident on 19/11/2023 has no relation with the cause of death of the deceased. However, it must be kept in mind that the investigation is at its nascent stage, and the IO is yet to examine the ocular evidence and other material witnesses to establish the truth. Sufficient opportunity needs to be given to the investigating agency to investigate into the matter and arrive at the truth of the matter. For this purpose, the continued detention of the accused persons in custody is necessitated for the purpose of fair investigation. Considering that the investigation is still at its nascent stage, I am not inclined to enlarge the accused persons on bail at this stage. Accordingly, in view of the aforesaid, the instant application praying for the release of the accused persons on bail stands dismissed and disposed of accordingly. Lordship, if my lord can kindly see the seals and signature of the Pescar, Lordship, because this fact is important, Lordship. In the same page, Lordship, page 85. Now, Lordship, when this bail application was rejected, Lordship, now this is the issue, Lordship, in this instant case. Where I am saying that the values of the original court as well as of this honorable court, Lordship, may be important, Lordship. Now, Lordship, when this bail was rejected, Lordship, the villagers of the accused persons, Lordship, led by one elder, a Gambura, Lordship, of their village, and about 50 to 60 youths, Lordship, went to the house of the trial court, Lordship. on the night of 23rd December, Lordship, at around 6:30 p.m., Lordship. And there is reliable information, Lordship, that the judge was not at home at that point of time, Lordship. But they heard verbal abuses. There is even information that, Lordship, someone broke the lock of the gate. Since now, Lordship, this fact, Lordship, is also supported by the document that I have annexed at Annexure 30, Lordship.
No, bail was cancelled on 22. Thereafter, what happened?
Lordship, I'll come to that fact, Lordship.
Okay.
If my Lord can kindly go to Annexure 30, Lordship.
Annexure?
Annexure 30.
29 is
Page 90, Lordship. That is my last Annexure, Lordship. Thereafter, Lordship, bail was allowed, Lordship. However, the circumstances in which the bail was allowed is explained by.
What is this page 90?
Page 90 is in the local dialect, Lordship, but the translated copy is at page 91, Lordship.
What is this?
Now, this is written by the Village Council of the Sessions Judge, Lordship, to the Village Council of the accused persons. This is a serious matter, Lordship. Mob trying to take over the judiciary, Lordship. Mob trying to impose their will on the judiciary. Might is not always right, my lord.
Yes.
Lordship, if my lord has read it, Lordship.
This was
Yes, shall I read it or?
fine only, I think. It was get out.
Yes, Lordship. This is a letter written by the Village Council of the Sessions Judge to the Village Council of the accused persons, Lordship. They are from the same tribe, Lordship. So, which is why the letter dated 20 January 2024 is written in their dialect, Lordship. Now, Lordship, interestingly, Lordship, after this, Lordship, another order was passed dated 22 December 2023, Lordship. That is the same day on which the bail was rejected.
Okay, this is. No, this. Okay.
Without any fresh application being made, Lordship.
So this was in January. This letter was written
in January, Lordship.
Chairman.
Yes, about the incident that happened on 23rd of December, Lordship, 2023.
Okay, going back.
Yes.
23rd of December, what happened?
The accused villagers, Lordship, the village men, perhaps their friends, their family, the villagers, they carry out the house, the residence, Lordship, of the district and sessions judge. Here it is written 50 to 60 youths. Now this letter is not my creation, Lordship. This is not the creation of the petitioner. This is a letter written by a village council to another village council, Lordship. Now, unless, Lordship, compelling circumstances exist, such letters will never be written, Lordship. Now, Lordship, interestingly, Lordship, thereafter, Lordship, the order by which I am aggrieved with, which I have annexed at page 29, was passed. Despite it being dated 22nd of December, Lordship.
The impugn order is at
Annexure 29, my lord, page 86. Lordship may kindly compare page 82 and page 86, Lordship. Page 82 and page 86.
what is it?
What is, one is, Lordship, 82 is the rejection order. That is same date, Lordship, 22nd of December 2023. And one is the order allowing the bail, Lordship.
Okay, on the same day.
Yes, Lordship.
So the 22/12 is a rejection order.
Yes, again, 22/12 is the allowing order, Lordship. Now, this is also certified by the
12.
Yes.
Bail allowed
Yes, Lordship.
on the same day.
Yes, Lordship, on the same date.
Subsequent, it was listed. Both the cases were.
No, Lordship, this pertains to the same.
No, the bail application number 787.
There is no bail application number,
That's a
Lordship.
clear case number.
Yes, Lordship. But Lordship, if, Lordship, there was a separate bail application, then opportunity should have been given to the PP also, Lordship, to be heard. If there was a review, Lordship,
No. So just a minute.
there was no such application, Lordship. So,
I think the order is also brought verbatim. Is it? Except for the last.
yes, Lordship.
What is this?
So same contents, my lord. One
Same
allows,
contents.
one rejects. Same contents.
Which one is the authentic one?
Both are authentic because both are certified true copy of the same court, Lordship. At this stage, how can we say, I'm not in a position to say which one.
No, your lordship, there's one point which this honorable court can note right at the outset. This is not an application filed by the state. This is not an application filed by the state. This is an application filed by a private party.
Private party.
Yes, ma'am.
Yes, Lordship.
So you are not filing through PP.
No, my lord. This is why, Lordship, I'll also come to that part, Lordship. In fact, Lordship,
Okay, after rejection,
yes,
then I think grant.
yes, Lordship.
We can't say, my lord. Which order came first, we don't know. Which order came first, we don't know. Your lordship, as the existence of two orders, I don't know.
Then the person is on bail now.
Yes.
Then I think the release is last.
Yes, Lordship, because if the release is,
Your lordship, that could be the first presumption which arises. But the point is, the petitioner alleges that we have used influence. The accused have used influence to secure the release order. But in the first place, where does the influence lie? That is the first question, your lordship. In the first place, where does the influence lie?
If they allow this the second, or the order where the bail is allowed was the first one, then the rejection was influenced.
Possibly, Your Lordship, because on both sides, the argument that is being raised is that they are a very influential people. They are saying that we are a very influential people.
So whosoever may be, must be a very influential. Yeah. Okay, yes. The last
Lordship,
one.
now if bail was granted first, then in the second order rejecting, it would have been mentioned that the earlier bail order is cancelled. The word cancel is not used there, Lordship. In Annexure 28, it would have been mentioned the order that I have passed on the same day, it stands cancelled.
What is stand cancel?
Yes, if say for example, if the release was first, if the release was first and rejection was last, Lordship, then in the rejection order, Lordship,
rejection was first.
Yes, it would have been mentioned that the bail allowing of the bail is cancelled. It is not mentioned. That means release was last.
Yes.
Yes, cancellation. Lordship has observed rightly. Yes. Yes.
So the last one was influential.
Yes.
Okay.
Now, Lordship, this order, Lordship, despite it being dated 22/12/2023, Lordship, it was not passed on this day, Lordship. Despite the Annexure 29, Lordship, despite this order being dated 22/12/2023, it was not passed on this day, Lordship.
Okay.
It was passed after the incident happened on 23rd of December at the residence of the trial judge, Lordship.
23rd of
December, Lordship, because
no, the 23rd of December is.
Yes, on that night, Lordship, the trial judge house was cleared out. So
on 23rd December.
Yes, Lordship.
Okay, so after this rejection, or after the
yes,
grant?
Yes, Lord, after it was rejected.
No, granting order was 26.
Okay, your allegation is that on 22 it was rejected.
Yes, which is right.
So thereafter, this Gerau was done.
Yes.
On 22nd,
Yes.
and then the order was actually written on 23rd.
Yes.
So it is dated back to 23rd.
Yes, Lordship. Because 23rd, from 23rd, the court was on holiday, trial court. December, Lordship.
Okay.
Christmas Eve, Lordship.
Okay. Yes.
Now, Lordship, if the bail bonds, Lordship, executed by the bailers, Lordship, if it can kindly be checked from the lower court records, Lordship, in order to ascertain, Lordship, when the accused were actually released.
When it was released?
Lordship, if the LCR may kindly be allowed to be perused, Lordship.
Just a minute. No, in the order sheet, the rejection has not been reflected, it appears.
Then Lordship,
Because after 28, so
then how did Annexure 28 come into existence, Lordship?
then on 22, order kept reserved.
Yes.
On 20, it was kept reserved. And the Land Council kept reserved.
Then perhaps the LCRs have also been manipulated. I'm sorry to say it, but Lordship, because Lordship, there cannot be two certified true copies, Lordship. One is reflected in the order, another is not reflected in the order. That cannot be, Lordship. Issued by the same PESCA of the same court. The signature is the same.
On 28, it was kept reserved. So 22, only one order, the record reflects only passing of in one order. Order kept reserved on so and so is passed in the separate sheet. The application paying for bail of the accused person is allowed. So that rejection order has not been reflected in the record. So that means the trial judge has passed only one order. So this has come.
Yes.
Where from you have brought?
That is what, Lordship. Lordship. It is, Lordship, I believe, a matter to be inquired into, Lordship. I will, at this stage, Lordship, this is, Lordship, this is being telecasted live, Lordship. The proceedings are being telecasted live, Lordship. If, Lordship, Lordship, if I disclose at Lordship, the source of my Annexure 28, Lordship, perhaps I may also be putting the person in jeopardy, Lordship.
Just a minute.
These things are serious, Lordship. Such incidents, Lordship, will erode the confidence of the commandment in the judiciary. And without public confidence,
what is the name of
the institution will crumble.
Just a minute. What is the name of this? There are other accused also who was released earlier, 6/12/2023. Born. What is the name of the accused?
Yes, I think that is Mishik, Lordship. Mishik, I think. Yes. I have also stated in my petition that, Lordship, the accused person, Shri Mishik, Lordship, he did not take part in the, despite him being an accused, he did not take part in the fight, Lordship. I have also mentioned in my petition, Lordship, that one of the accused persons, Lordship, he did not take part in the fight.
Okay, just a minute.
Perhaps he is the one who was released on bail, Lordship. Because in the order allowing bail, Lordship, at paragraph 2, the name of Mishik is missing.
What is the name of the present accused? 21.
5 of them, Lordship. Respondents 2 to 7, Lordship. 2 to 6, Lordship. The names of the accused, our lordship,
2 to 7,
2 to 6, my lord.
2 to 6.
Yes.
It's fine. 2 to 6. It was on 21. Bail on 21. Bail was granted on 22.
Yes, lordship.
Accepted on.
Bail was rejected as well as granted on 22.
Just a minute, sir. Jailer signed on 21. Bail. So this whole verification done on 21. Accepted on 24.
Kita harus.
Okay, it was 24. From the jail, it was signed on 21. Bail was granted on 22 only.
Yes, lordship.
22.
Yes, lordship.
This affidavit was signed on 20.
Lordship. Now the bail bond, lordship. If
Before
it
the
can-
notary.
Lordship. Because on the day of release, lordship, a bail bond is executed. If that can kindly be checked from the LCRs, lordship.
This was signed in anticipation.
Lordship, a bail bond, lordship.
Bail bond, of course, executed on 24th.
What
Lordship, that is what, lordship.
What affidavit, my lord, if I may explain?
This is actually affidavit. The statement and so the affidavit is sworn for the purpose of declare that bailor in the instant case for the release of so and so.
Yes. That is separately, lordship. That is a part of the bail application.
Bail
The bailers are
part
supposed
of
to
bail
execute.
application
Yes,
only.
yes.
Okay. So, okay, then it was executed only on 24th after the release, after
Yes.
grant of bail.
That means, lordship, they were released on 24th.
Yes. Executed on 24th.
Yes, because that.
There is only after, of course, after grant of bail on 22.
Yes, lordship.
That is
Lordship.
correct.
Lordship. They were released on 24th.
Yes.
Now, lordship, this is my case.
Executed on 24th.
Yes, executed on 20. They were released on 24th, not
Okay.
on 22nd. But this is my case, lordship. The incident, the bail rejection happened on 22. The next day, the house was cleared out. On 24, the bail order, which I've annexed, allowing the bail, order dated 22, was made.
Passed on 23rd.
Was actually passed on 24th morning, lordship, but it was predated and written as if it was passed on 22nd, because 24th is a holiday, lordship, Christmas Eve, lordship.
Executed so
And
on
there were on the basis of the order that dated, pre-dated order, Lordship, they were released on Christmas Eve, Lordship, on 24th.
Yes.
Now, how come the rejection order is not part of the record, Lordship? That is a relevant question, Lordship.
The rejection order is not on record. We'll have to call for. If there is any other record other than this. Because if this order was passed by the learned trial court, it has to be.
Yes, Lordship. And Lordship can kindly see the seal and compare the seal and signature, Lordship, of Annexure 29 and 30, Lordship. The same signature, the same.
Granting order, I think is the original, it was signed on order granting bail.
Yes.
Is 22. And this, I think, is the original.
Your Lordship,
Yes,
if I may
Please,
interject for a moment.
yes.
Now, the tenure of this application is going on a totally different tangent. This is an application under 439. That was not by the state, but by a private party. Under 439, cancellation of bail, 439-2, the grounds are limited. In this application, I understand the anxieties of my learned friend for his client, but it's taking a totally different line. It's
Yes, a different line. That is why we are here.
yes, my lord.
And otherwise, for bail cancellation, limited, of course.
Very limited.
Very, very limited.
So this is 439-2.
Only violation.
Yes, we cannot go
That-
beyond
that
that
is
now.
why-
We cannot go beyond that.
But here,
Lordship, yes,
In
but
that case, if my learned friend is raising certain allegations about the conduct of the case, then it has to be by way of a different application and it is
No.
a different forum, not by way of 439-2.
Lordship, here, Lordship, I have filed by
so that
application.
can also be, of course, ground, what he is
Yes.
speaking. But then, only the thing, of course, what we have raised
Yes, my lord.
is that it is not being filed by the PP,
Yes, my lord.
through PP.
It has not been filed. The state is not agreed. The state is not agreed, my lord. That is the point. The state is not agreed.
Whereas state knows about this, no? State knows about this,
Your Lordship,
the
report,
allegation,
we are
because
relying
it
on
is
the
in the
report.
petition.
Yes,
Yes.
yes.
I
So,
think you have
we
made
are
this, all
relying on
this
the
in the
report.
petition also.
Yes, they are a party, Lordship.
Yes, we are make
Yes.
respondent number 1.
Yes.
And we are relying on the report, Your Lordship, the LCM.
And not only that, your
State
lordship,
should be the one who should be filing.
actually,
Your
Yes,
Your
Lordship. Yes, Lordship is absolutely right.
Say-
Lordship.
But here, the state has been made a,
In this petition, yes,
Hmm.
the accuses, Your Lordship, the complainant has taken that.
how do you justify that state is not filing and it's the individual,
It should
the
be
private
under
person?
section.
And Lordship,
Yes, yes.
if I may, Lordship,
Other
yes.
issues may be taken up on another thing.
2023,
Can also be
yes,
victim.
paragraph 13, Lordship.
there, lordship, no, my lord, one point. Cancellation of bail by the private party is all right. But going beyond the scope of 439-2, that's a different point altogether.
Lordship, here, Lordship,
And the law on that point is already settled, your lordship. Under 439-2, if an application for cancellation of bail is being filed, the grounds urged must be that the terms of bail have been violated, that's all.
The circumstances of the case, Lordship, is not being properly appreciated, I think, by my learned senior
laws-
counsel,
The
Lordship.
law is settled, my lord. 439, you must confine to the grounds of 439.
Now, Lordship,
If you wish to raise any other grievances,
I
you file a
have-
separate application.
No, Lordship, I have filed this present petition, Lordship, because this is a certified true copy issued by the Pescar, Lordship, on the ground that this exists, Lordship. Now, only when LCR is called for, it is coming to my knowledge, Lordship, that this is not part of the record, Lordship. Now, this is
I
a,
have no idea if there is any other records.
yes, Lordship.
Is another point which in terms of the Evidence Act, your lordship,
Yes.
proceedings in court, the records, there is a presumption that they are genuine records and orders have been passed by the court. If he wishes to make any allegations, it has to be by way of a separate application, not by way of 439.
This court has also powers, Lordship, to exercise supervisory jurisdiction under 227 of the Constitution of India. No? It can be done suo motu.
But not in this application.
This is a serious matter, Lordship. Two certified true copies, one is not part of the record. That means either I have manufactured this or somebody has tempered the record before the
Your
trial
Lordship,
court.
Since my other friend is taking this issue very seriously, I must also take it very seriously. The point is this, your lordship. 18th of November, the incident happened. 19th early morning. He was admitted to hospital on 19th. He was released on the 22nd in good condition. But the petitioner has failed. He's not disclosing that in the report on the 22nd, there is a finding of the doctor that he is suffering from liver cirrhosis. The deceased is suffering from liver cirrhosis. What happened on the 18th night and early morning 19th? They were all drinking. They got into a drunken brawl. Both sides. They got into a drunken brawl. What happened? The deceased took a swing at one of the accused in this case. Unsteady on his face, unsteady on his feet. He fell onto the hard surface of the ground. He broke his jaw. He was released on the 22nd on his own demand, on his own volition. He did not take further treatment. He did not even take treatment for his jaws. He remained like that, your lordship. In the petitioner in this case, the brother of the deceased, he is the one who prepared the compromise deed. The instant petitioner. We did not prepare it. Then the most important point, your lordship, if there is an allegation of an unnatural death, there must be an inquest report. There must be a post-mortem report. On these basis only, police can register a case. So the first FIR was closed. The first FIR was closed on the basis of the compromise deed. And that your lordship can see in the letter of the IO himself. It is not as if that the police did not take any action on the FIR. The first FIR was closed. That is why they registered the second GDE. In spite of not having evidence to show unnatural death, they registered the second FIR. Who has the influence, your lordship? That's why I was saying influence from the very first instance. Your lordship, may kindly look at the report of the police officer. I have enclosed that to my written objection. It is very telling, your lordship. Very telling. At page 42 of my written objection. Page 42 of my written objection.
Yes.
This is not very clear. I have enclosed a typed copy at page 44. Lordship can come to page 44.
Yes.
This is addressed to the Chief Judicial Magistrate by the IO. Madam, with reference to the subject cited above and the referred case, I have the honor to report that on dated 19/11/23, a written FIR was received from Navesh Shohair of Iralibil village, Dimapur, stating that on 19/11/23, around 12 a.m. to 1 a.m., some unknown miscreants attacked them when they were leaving from Nagajan Junction. Accordingly, their FIR was received as entered by ECPS GD number 11 of 23, dated 18/11/23, and the inquiry was conducted by ASI Ikato IME. It is a false statement to say that nothing was done on the basis of the first FIR. Absolutely false statement, your lordship. That is what is being argued right now. On dated 28/11/23, the complainant and the victim's family provided a compromise deed dated 27/11/23.
The complainant and the victims?
Yes.
Okay. Provided.
Yes. Written on an affidavit made between the two parties and signed by both the parties. As the compromise deed was received from the complainant and the victim's family, the inquiry report was finished and kept ready to submit. Case was closed, your lordship. On 4/12/23, the deceased family reported that the PS, along with a written complaint request for registering additional complaint, a fresh FIR was filed. It is not an additional complaint, Your Lordship. A fresh complaint was filed, along with death certificate from CHR stating that Nuto Aomi has expired on 1/12/23, and on subsequent submission of inquiry report by the inquiry officer ASI Ikata Aomi, a case was registered at ESPS number, PS case number 20 under section, even the sections, Your Lordship will see. 302, a case of murder. A case of murder, how do you establish murder, Your Lordship? Unnatural death. In the first instance, you must have an inquest report, you must have a post-mortem report. All these grounds were not taken into consideration. Purely on the pressure of the petitioner, the police registered a second FIR. And the case endorsed to SI Bangkatong Sikitan of East PS for further investigation. The registration of the case was entered in East PS case GD 14/23, another GD, not the old GD, another GD dated 4/12/23. That Madam, on 5/12/23, the below mentioned 5 accused persons were granted interim and anticipatory bail by the Honorable Court of Principal and District Sessions Judge by order dated 5/12/23. During the interim bail period, the below mentioned 5 accused persons reported before the IR of the case on 6/12/23 and were shown arrested and later released on bail as per the direction of the Honorable Sessions Court order. We complied with the conditions of the interim bail order, sir, Your Lordship. Then on 12/12/23, as directed by the Honorable Sessions Court, the status report of the case was submitted to the Honorable Sessions Court. And basing on the status report, the Honorable Sessions Court was pleased to pass an order dated 12/12/23, passed on in 7/11/23 and IA 7/15/23, cancelling the interim bail order dated 5/12/23 and allowing for custody of the bail below noted accused persons. Therefore, the 5 below noted accused persons were remanded to 7 days police remand in respect of the police investigation. It continues on to the next page, but the next page is not very clear. I could not go to type that, Your Lordship, but the original copy is at page 43. Lordship has page 43.
Yes.
Then the second paragraph, first paragraph is not very legible, Your Lordship. That Madam, active investigation is going on, and given the gravity of the case, there are more facts to be ascertained, and their custody is required for a fair and just investigation of the case. I therefore forward the below noted accused person before the Honorable Court with a prayer for 15 days judicial custody. Even the investigation was over, Your Lordship. No more police custody was required. So even the police know that there is no case against the accused. And in fact, Your Lordship, look at the death report. Death certificate. What does the death certificate say? Your Lordship, we can kindly come to the death certificate. At page 34. At page 34. Type copies at page 35. Cause of death, primary hypovolemic shock. Death due to secondary upper gastrointestinal bleed. Decompensated chronic liver disease. So if you bleed excessively, Your Lordship, the heart finds it difficult to pump blood and it goes into hypovolemic shock. So decompensated chronic liver disease, it leads to bleeds, Your Lordship. So this person was suffering from chronic liver disease, liver cirrhosis. He was an alcoholic, Your Lordship. Even in the first report which the petitioner has enclosed in his own affidavit, in his own petition, Your Lordship, we can come to page 38. And page Department of this is the discharge summary, Your Lordship. This discharge summary, and there are some reports enclosed to it of the abdomen. If Your Honor can kindly come to the abdomen. That is at page 38. What is it? Page 38. Page 38. Page 38.
Yes.
This is during the first hospitalization. And this is the NCCT whole abdomen. And at the bottom of the page, impression. Does the Lordship come to that? Impression.
Yes.
CT abdomen reveals feature likely to present chronic liver disease, minimal ascites. So this is a person who was suffering from liver cirrhosis. His death had nothing to do with the incident which occurred on the 18th night and early 19th morning. The police know that. The police know that. And yet, because of the influence of the petitioner, a case was registered. We complied with the directions passed by the Honorable Court. We surrendered. We were taken into custody. From the date of the release, another important point, Your Lordship may kindly note. From the date of the release on 24th of December, Your Lordship, from the date of the release on 24th December, they have not been summoned even once by the IO till today.
Case has been charge sheeted?
No charge sheet.
No charge.
They have not been summoned even once. So how do you, in the first place, Your Lordship, it is not as if the FIR has been filed for the first time. The first FIR was closed. A second FIR was filed. A second FIR was taken on board without any evidence against the accused. So where does the influence lie? Where does the finger pointing actually go? That is the point, my lord. Even the Lordship, we even see the compromise deed. The compromise deed is dated 27/11/23, which is at page 31 of my application, of my objection. Page 31. Type copy is at page 32.
Yes.
This deed of compromise is made on the 27th November 2023 between Shri Nuto P. Aomi, that is the deceased, resident of Diffupar A village, and two, Shri Kevin Yepthomi, Tokavik Kiba, and Shri Japito Zimo. That on 19th November 2023, around 12 a.m. to 1 a.m., the second party, without any provocation, has assaulted the victim first party, causing serious injuries, fracturing both the jaws on the right and 2 centimeters on the left, and was admitted to the ICU Olive Hospital, urgent surgery. That is second party assailants approached the first party and requested to forgive their actions, and on considering the request made by the second party, the first party in good faith had forgiven them. However, with the condition that the second party promised to bear all the medical expenses incurred during the entire course of treatment. In view of the compromise made between the two parties, the first party will withdraw the FIR, which was filed on 19 November 2023 against the second party, in witness whereof this deed of compromise is signed with sound and robust held without force. Now, who prepared this? Who prepared this, Your Lordship? This compromise deed was prepared by none other than the petitioner in this instant case. And who signed this? None other than the deceased. And on the basis of this compromise, the first FIR was closed. The first FIR was closed. That was why a second GD entry was recorded. And Your Lordship can also see the application which was submitted by them. In pursuance of this compromise deed, Your Lordship, I also paid them the sum of rupees 1,50,000, which they accepted. After the deceased died, they returned that amount to me. That's a different story. But I gave them the sum of rupees 1,50,000 to cover the medical expenses, which they accepted. And look at what is the second FIR. I call it a second FIR, Your Lordship. It is not an application to the Commissioner of Police. It is very cleverly addressed to the Commissioner of Police, but it is a fresh FIR. Your Lordship can see that at page 36. Page 36 of my written objection. May I read, my lord?
Yes.
This is addressed to the Commissioner of Police. Request for registering additional complaint. Respected sir, this is in connection with complaint dated 18/11/23 having GDE 11 of 23 filed before East Police Station. Sir, it is humbly informed to you that on 18/11/23, my younger brother late Newto, so and so, along with his three friends, namely such and such, were exiting the restaurant and heading towards their cars when out of nowhere and unprovoked, my brother and three of his friends were attacked by 6 persons, 3 of whom have been identified as such and such. The remaining 3 are currently unidentified at the time of filing of this present complaint. It is a new complaint, Your Lordship. There is just a reference to the previous complaint. It is a new complaint that my brother, seeing his friends being assaulted, intervened and tried to stop the assault. However, unfortunately, one of the accused persons hit him on the back of his head, causing him to fall and hit his head on the concrete floor. Therefore, the accused persons kicked him several times, owing to which he was unable to get up on his own. Seeing my brother on the floor, his friend Mr. Navi Shohar picked him up and put him on the car, and subsequently, they all headed to the East Police Station to file the complaint dated 18/11/23. That since filing of the aforementioned complaint, my brother was hospitalized, where he succumbed to his injuries and died on 1/12/23. In view of the above, it is my humble request that you register my complaint and arrest the accused persons and prosecute them as per law. It is a fresh FIR. The language is very clear. And not only that, Your Lordship, on the morning of the 18th, late night 18th, 19th, early morning, the altercation took place for just about half a minute. There was a patrolling IRB party. The patrolling IRB party broke up the fight. Half a minute. Half a minute, Your Lordship. And what are the actual facts of the case? Your Lordship, I have mentioned those facts in paragraph 2 of my application. In paragraph 2 of my objection. Can I take Your Lordship to paragraph 2 of my objection?
Paragraph 2.
Yes. May I read, my lord? Paragraph 2 at page 2. May I read, my lord?
Yes, sir. Paragraph 2.
Yes, ma'am. Paragraph 2, page 2.
Yes.
That the petitioner has not disclosed full facts and particulars in relation to the matter at hand. As such, the answering respondents pray for the indulgence of this honorable court for leave to place the same on record as hereunder. On 18/11/23, sometime between 9 to 10 p.m., the respondents 2, 3, and 4 went to I Karaoke restaurant at Nagajan, Dimapur. This restaurant provides facilities for karaoke singing. The aforesaid respondents, after waiting for their turn, took the 2 available microphones. While singing and selecting songs of their choice, they noticed that one of the microphones was missing from their table. Not paying much mind to the same, they began singing, whereupon they found voices coming from the other microphone. It was here that for the first time, the said 3 respondents noticed the deceased Newto Aomi and 2 of his friends, Puto Chopi and Inabe Shohei. Since the singing from the 2 tables was clashing, as the persons who had prior reservation to the karaoke system, the respondent number 2 went to their table and requested them to hand over the second microphone. They were reluctant to hand over the microphone, but since the same was on their table, the respondent number 2 picked it up and returned to his table. They continued singing thereafter. The other group, that is, the group of Newto Aomi, openly expressed their displeasure. As such, tensions arose between the 2 groups. However, the 2 groups kept to themselves whilst they were in the restaurant. Both groups were intoxicated and under the influence of alcohol. While the respondents numbers 2, 3, and 4 continued with their singing, the other group left the restaurant. They left first. When the said 3 respondents exited the restaurant after midnight, they found Newto Aomi and his 2 friends waiting for them. At about the same time, the respondents 5 and 6, along with their friend Mishak, also exited from the Snooker Gaming Center in the same building. Seeing the respondent number 2, the person who took the microphone away from the table, Newto Aomi and Inabe Shohei, his companion, became aggressive, calling him mannerless. Given the intoxicated condition, tempers began to flare. The respondents numbers 5 and 6 and their friends intervened to try and stop the 2 groups from fighting. However, one person from late Newto Aomi's group threw the respondent number 2 to the ground. At the same time, Newto Aomi's companion Inabe Shohei threw a punch at the respondent number 3. Newto Aomi and his friends began violently attacking the answering respondents. What resulted is a free-for-all session of fisticuffs. About half a minute into the fisticuffs, a contingent of IRB personnel patrolling nearby stepped in and stopped the fight. It is in the knowledge of all the answering respondents that blows were exchanged, but none from Newto Aomi and his group were kicked or hit on the head. During the short exchange of fisticuffs, Newto Aomi, who was fully intoxicated and unsteady on his feet, took a swing at one from amongst the answering respondents. However, given his intoxicated state, he did not connect but fell face down onto the hard surface of the metal road. With the intervention of the IRB, everyone dispersed. Sometime in the evening of 19/11/23, the proprietor of I Karaoke restaurant called up the respondent number 4 and informed him that Newto Aomi had been hospitalized and that the police is looking for him and his friends. Pursuant to an FIR lodged by Inavi Shohab, the aforesaid companion of late Nito Ahami. The respondents 2, 3, and 4 were informed by the police that they should be present. They should present themselves before the police station. Accordingly, on 2011-23, all of them proceeded to East Police Station, Liverpool. We are not evading any process of investigation, Your Worship. In the police station, they found the family of Nito Ahami, including the petitioner here present, along with Inavi Shohab, Uto Chopi, as well as the wife of Nito Ahami. They inquired from the respondents 2, 3, and 4 as to who assaulted Nito Ahami. The said respondents replied that what happened on the night on 18/11/23 and 19/11/23 was a drunken brawl, and that everyone was involved, including Nito Ahami's group. The group representing Nito Ahami told the respondents 2, 3, and 4 that they would forgive them, but they would have to bear the expenses for Nito Ahami's medical treatment. The offer and acceptance of the compromise was made in the presence of the IO of the case. Since the parties wanted to execute a said compromise on stamp paper, the IO advised them to execute the same elsewhere and submit the same. As such, a compromise deed dated 27/11/23 was executed between Nito Ahami and the respondents 2, 3, and 4. This agreement specifically records that the said respondents will bear all the medical expenses incurred by the treatment of Nito Ahami, and that the FIR filed on 19/11/23 will be withdrawn. The compromise deed was prepared by late Ahami and his elder brother, the petitioner here.
In fact, so,
Lordship,
what we'll do,
if LCR maybe
yes,
recalled again,
what we'll
Lordship,
do,
asking whether Annexure 29.
yes, you also just, what is this ruling is? What this say?
It says why the complainant, Lordship, can make an appeal for an approach court, Lordship, or even the Supreme Court, Lordship.
Appeal.
Not appeal, Lordship, for cancellation of praying for cancellation of bail, Lordship.
Okay, the complainant can
The
also.
victim's family, the complainants, Lordship. And here, Lordship, the Supreme Court has lamented the fact that, Lordship, the state has not come for appeal for cancellation of the bail, Lordship.
It cannot be a mechanical exercise, Your Lordship, for the state. The state finds that there is no
So
reason.
the private respondent, the private or the victim can come by way of cancellation or by appeal.
By way of, Lordship, the present petition, Lordship.
Because you are alleging something else also here.
Yes.
Yes. Now, Lordship, that allegation, Lordship, has come when LCR has been called, Lordship.
No. It was there from the first one.
Cancellation is a limitation, you see.
Yes.
Anyway, you just work it out, see it. So, what we'll do, and you also obtain, because this probably is not a complete LCR. Because if this is correct, the true copy of the second, the rejecting bail is also correct, then probably there are some more in the record, should be in the LCR. So it is not there. You just see it, and then you also obtain confirm that if this is the entire LCR of
That may be true registry, Your Lordship.
True registry.
Yes.
It was called true registry.
Yes.
Okay. Okay. So by which order the LCR was called for?
2/4/2024. 2nd of April 2024.
You have that order.
I don't know, but it's in my file note.
It was called, sorry, it's a case diary. It was
Yes,
called for
this-
case diary.
Actually, the case there was called for.
So this is still in the investigation stage.
Yes.
So I think the case diary.
Yes.
But then
But
this case
since
diary
LCR
also,
yes.
the court should also have the record, because the order was passed by the court, learned court only.
My lord, my lord.
Okay. Mr. Santiago, and counsel for the petitioner. We also had Ms. Meredith and a PP, and Mr. Jimome, and counsel for the private respondent.
Yes, madam.
Number 226.
Yes, lordship.
Stop. By an order dated 2/4/2024, the case study in connection with Dimapur East PS case, number 292/2023, under section 302, 323, 325, 34 IPC. Was called for. So the order says then the case that will be produced by the next day, on the next date by the learned additional public prosecutor. The order
Your
reflects.
Lordship, I have a scanned copy, but not the updated one.
No, yeah, the order also
The
says,
draft of
order also says that it should be produced by the learned additional public prosecutor.
Lordship.
So
Till
it's the case study.
March, Your Lordship, 24 I have.
Okay,
Yes,
so you produce the updated one then?
Lordship, Lordship.
However, on the case study received and perused, however, received, however, on perusal of the case study, it appears that some of documents. Okay, just a minute. Our learned additional PP submits that the case diary case diary which is available before the court is not the updated one, and prays for some time. Stop. List this matter on when?
Coming Tuesday, madam?
Coming Tuesday, Lordship, I may have difficulty, Lordship. I have
Okay,
I have fixed matter
when do you want?
in court one on Tuesday, Lordship.
When?
After a week, Lordship.
After a week.
30th, madam? 30th?
30. List this matter on. Date to be fixed. Yes, there can it come? Okay.
Scanned copy.
Is prayed for by the Learned Council for a party. List this matter on 30th. On which date the Learned additional PP shall produce the updated case diary. Okay.
Lordship, maybe.
So you also just see the provisions.
My lord, my lord.
Yes.
Lordship, may the matter be kept as part heard so that we can take it up early?
I'll be there on 30th. This code will be
Lordship,
there.
for the purposes of the consulate, if it is part heard,
Proceedings, I think.
Lordship, and Lordship, if we are unable to take it up, then if my Lordship does not sit on the next day, then it may become a problem, Lordship.
No. What is?
Let it not be kept as part heard, Lordship, because if it is under, if.
So this court will sit on 30.
Yes, my lord.
Without saying part heard.
My lord.
This court will take up on.
My lord, my lord.
Okay.
Lordship, part heard because it'll take precedence if the other matters are listed. Yes. That is the only reason why.
Okay, list,
Yes.
List it as part heard, okay. Then just a minute, Any other matter in the motion or order stage there is? Okay, so because what I thought, some part heard hearing matter, we will not be able to test the entire except one, I think.
In today's list, madam?
Yes. So there is part heard matter also 13 will be able to take, but then the rest probably will not be able to take up. Not the 30.
So in the supplementary item.
Yes, item number 30 we can take, but then the rest hearing items we may not be able to take up.
So
we'll
in
have
that
to
case, earlier in the morning I have mentioned, my learned friend has
Yes,
come.
yes. Which item?
Item 18.
18.
Yes, sir.
Okay, when do you want?
Lordship, after 2 weeks.
Okay.
Lordship, a date may be fixed.
On a joint prayer made by Mr. Pope.
Yes, sir.
Founder and, sorry, B. Devnath, Learned Council for the appellant, and Mr. Pope, Founder, Learned Council for the respondent. Please this matter.
Lordship, on the second week of June.
During the second week of, in the second
week.
The second week of June. Okay.
Obliged, Lord.
Okay.
Lordship, I beg to mention item number 11 of order, Lordship.
11.
Lordship.
This is report also awaited.
Yes, report awaited, Lordship.
Mr. Devnath is present. As per the report, as per the office note, the service report is still awaited. In view of the above, release it matter after a week.
Oh,
after 3 weeks. Coincide with that 3 weeks.
Lordship.
Okay, after 3 weeks. Okay. Yes.
Okay.
May please, Your Lordship, with the consent of the opposite party, I beg to mention item number 33.
33.
Yes, Your Lordship. As per last order, it was supposed to be listed on 26th of June, 2024. However, it was wrongly listed
The
today.
process also could not be complete. Probably, okay, when do you want? You are for?
Respondent number 1 and 2.
1 and 2, okay. Okay, Mr. You are for the petition? No, okay. Let's pray for by the Lana Council for the respondent. List this matter after.
This matter has been listed as per last order, 26th of June, 2024.
Okay. When do you want that?
26th
26th
of June.
This 26th of June.
Yes, Your Lordship.
Okay, list this matter on 26th of June. After 26th of June, I
No,
think.
26.
26.
Yes,
You are for respondent in the contempt.
yes, 1 and
No, I think that
appearing on behalf of my senior.
so I think the imposition of this model code is up to 26. Your prayer is only after 26, I think. In other matter also like it, after 26 of June. In this matter after 26 of June. Okay.
Right.
Yes, yours.
Lordship, I'd like to mention item number 14.
14.
Yes, Lordship. If this matter can come up after 4 weeks.
You are for?
I'm for the appellant. Lordship.
Okay. Mr.
No more on behalf of Noksung Tila.
Okay. On behalf of Noksung Tila, Lana Council for the appellant, praise for listing this matter after
4 weeks.
4 weeks. The prayer is allowed. List this
Lordship, if
matter after
in the
4
meantime,
weeks.
Lordship, if in the meantime, Lordship, if your Lordship allows, I may be allowed to file my written argument. Why? Reason being, the matter is an old case, Lordship. The LCR is also bulky. So in order to assist the
in 14,
Honorable Court.
Item 14.
Yes, Lordship.
So hearing not yet completed, I think.
No, it's fixed for hearing.
Which one?
Item number 14.
14 is not a fixed item. Only 13 is fixed. Part had fixed.
Okay.
After hearing, I think you will be asked to file written submission also. Okay. So how many items you have there? They will be there. Hearing method.
My lord.
Okay.
My lord.
Yes.
Please follow me, Mr. Item 10. Order, under order.
Yes. What do you want there?
I have communicated with the council of the FCI and so they are ready to appear. So the matter may be listed after a week, after 1 week.
Okay. Let's pray for by Mr. Pakin Chapo, Lana Council for the petition. List this matter after a week.
Item number 9B. Masuk Puji Jija. Order 2 weeks.
Sĩ điều là cấm này thôi. Tại các chúng tôi có sĩ điều rồi. À, rồi bị sĩ điều rồi rồi. Yes,
For hearing item number 13.
There are also some other fixed matter, I think. Which one?
Item number 34.
34. 34. Yes, sir. Sir, will we be able to, if we continue with this, I just would like to record their statement or record their submission also. And if we continue with this, probably we may not be able to take up this 34. What do we do? Because, and then once I take up this matter, there are other CAB also, and then this I would like to continue. And then if I don't want to keep CAB so much of CAB.
He is from Dimapur, so unless
So if you can just accommodate few more days, last part of this month, next week, I mean,
Next week,
because
Monday.
this week,
Monday.
this and the other matter will covered.
Monday on Monday.
Monday,
Yes.
27.
27.
It's okay, no?
We can do on
Yes,
Monday
yes,
because
yes.
this week, this will cover
I see.
along with the other CABs.
I see.
So
That's
Monday,
right.
then
That's right.
I'll carry it as a
Sorry.
CAB. Okay, thank you.
Yes.
And then what I'll do, I'll record. Just I should have announced in the morning because they also did not inform me that there shouldn't be any so many of fixed matter.
Yes.
Part at least, nah? Because sometimes it takes long time.
Yes.
And from the next time, so part hard matter once in a day, part hard, once in a day, nah?
Yes.
Only one part hard matter item in a day. So two case, sometime in the longer case, we may not be able to hear two part hard matter. No, so that is with the view to dispose of. So we can't take up two or more than one. No? So rest other hearing can be done, but then part hard it is with the only with the view to dispose of. Yeah. So this so just see your record. If there is already there is a part hard matter, then no two cases. No? Try other case may be fixed. Oh yes. Hard, Mr. Ariralo, National Council, assisted by Miss. Okay, her name, huh? You're Maveni, na? Okay, and counsel for the appellant, and Mr. Ankel will come, and counsel for the respondent. Yeah, respondent, huh? Stop. On the consent, on the agreement of the party, on being agreed by the party, this is matter on 27th as a part hard. Huh? This is matter for hearing as a part hard matter. Huh? Okay. Okay. Whatever this 32, whatever this 32 done, na?
So already mentioned.
Or mentioned.
32. Court order was passed.
Okay, okay. Okay, already passed. Then this is the last?
This is the last agreement.
Okay. So now we can go. This is item 13. 12 is which? This is 13. Yes, yes, hearing item number 13. So who is for the petitioner?
For the petition.
You're for the petitioner. Who is for the respondent number 5? You are for the respondent number 5, yes. Okay, only one thing I just would like to confirm. You are repeatedly alleging the forging of the signature or the false ownership. So, and according to you, the department has not taken into note of this. Okay, and then because of that, the private respondent number 5 have been appointed or has been appointed. So, have you filed any FIR to that effect or any persons? Then unless you said because you are alleging that she has forged the signature also. So unless there is a findings or unless there is complaint, and then so how do we agree with that?
Your Lordship, this matter was taken up by the village council and by the village council.
File?
Village council of the young.
No, village council.
Your Lordship, and Your Lordship.
No. Because in all your, even the written submission also, this is the point in repeatedly in 3 point, out of 4. These things has repeatedly coming. Forging of documents. Grounds. This is ground for setting aside of the appointment order. And then the village council has said that we did not issue.
Yes, Your Lordship.
It is the case. We did not. Whether the village council has filed FIR that my signature has been forged.
No FIR.
Then this should have been.
But they have written a representation to the department regarding the issue.
So whether the department has taken some action on that?
No, Your Lordship.
Because the department, if apprised by the council person concerned, should have actually. So department has not taken.
No.
So but the department has received the complaint from the petitioner.
That one I need to ascertain, my lord, whether the department has received the complaint on.
Because time and again or repeatedly the contention of the petitioner is on that. It's a main ground for rejection of the setting aside and question of the appointment order because forged. And then the village council also says, and then department submitted, and then it's on, and then in your affidavit also probably this has not been denied. So you need actually should have obtained instruction. And how do we go about this? Because unless their allegation is that unless denied, you did not deny. Unless denied, it is accepted that it is admitted in the plaint, in the petition.
My lord, in this regard, I need to obtain instruction
You
because whether the petitioner have filed complaint or not. Because
do you have the copy of the complaint filed before the department?
Yes, Your Lordship. I have annexed in my writ petition.
Kindly, which annex, sir? Do you have the copy of the petition? Kindly see. Because this is the main ground, and then the first ground for forging of documents, and then also, and third ground also.
Your Lordship.
Then the second ground.
Page 15 of
Page
my
15 of your
the petition.
page 15.
Your Lordship, page 16. This is the
16.
Yes, translated copy.
Principal Director.
Yes, Your Lordship.
So writing paid also.
Yes, and Your Lordship.
They are the landowner that said plot of land. But we would like to inform and clarify you that they are not the landowner of that said land, and also without the knowledge of the Yongjin Sen village council, he had misused the writing paid and forced the signature of the members as well. And therefore, we, the Jimsen village council, had held a meeting on so and so and had taken befitting action against them. So what action was taken?
Your Lordship, can you please refer to page 17? Next page. Your Lordship, this is a representation submitted by the village council, and we have annexed. They have annexed.
So this environment, which paragraph you have made this environment? This is annexer E and annexer E and E. So annexer E and D. So paragraph, I think 2. Para 2.
E, F.
No, A, D, M. Para 2, E and F.
E, no? F.
So there is an allegation. And what is your reply? Let us see. Your affidavit, your government affidavit, and your 1, 2, and 3. You have no comments. You say no comments. And let us see the affidavit of private respondent number 5. No, this is, sorry, affidavit in reply. Sorry, just a minute. This affidavit in opposition. Let us see. See, yeah. One, two, three, four. One. Where about the two? 2A, 2K. Answering deported answer. However, the deported harmless instead. On earlier occasion has filed WPC challenging the answer. Because your appointment is based on the land ownership.
Yes.
And the very basis she is challenging. She has challenged. Probably that government you have not replied. No.
Yes, that one in our paragraph 4, but we have not justified that.
Not justified, and probably you did not receive any instruction also.
Yes,
it appears.
Yes.
But then unless that is reputed, so it is treated to, and what did you say? Because it is allegation is against you.
Nothing much has been status. Nothing much has been replied back specifically, but your lordship, as far as this allegation is concerned, with regard to the forgery, I don't think it is the village council or the department can decide these issues. This particular issue.
No. But the allegation is made, and then he has submitted representation before the department.
Yes, sir.
And then after submission of the after complaint, logic complaint,
yes,
and which was submitted forwarded to the department, submitted to the department. Thereafter, petition filed.
Yes.
And in the petition also the same allegation, and then it is the department who should take some action. So refuse. It was not there on irrelevant, whatever maybe, but then no justification there. And probably neglected. And you also, because the allegation is basically upon you only.
Yes.
Because the allegation is that department is given you on the basis of the land ownership. But then your land ownership, the very basis has been challenged, that you have obtained this land ownership certificate on the basis of which you got the employment is forged one. So this is her allegation.
Yes. Allegation.
So unless it is refuted or unless it is denied, specifically denied, does it not mean to have admitted?
Yes. The general principle is that, but given the present situation, your lordship,
yes,
they are making statements that they have complained to the department as well as to the village council. But forgery is a case where an expertise will be required. And to prove that,
no,
they have not filed FIR.
Not expertise. Here, the basic allegation is that you have forced. And that the village council also already issued that we did not sign. When he refused, and then if you, of course, says that no, you have signed, now you are telling lie. Then of course it can be sent to the
As
expert.
far as that is concerned, I have not refuted, but I have also not admitted their allegation, but
You have to do either of them.
Yes.
Either denied or admit.
I might have not, I might, to the opposite, I might have overlooked the reply,
Then
but
it is then
Your Lordship, may you please refer to page number 18?
it is then admitted. And under the circumstances, your very basis has been challenged. And your appointment is basing on the land ownership only.
this particular allegation is something of a forgery which is criminal in nature, and then it has to be established.
Yeah, that is why I'm
beyond
saying.
reasonable doubt by a competent court, Your
That
Lordship.
is why I'm saying that whether she has filed FIR.
Yes, yeah.
But then instead of filing FIR,
Yes,
she lodged complaint.
yes,
And then on the basis of her, probably
yes.
her complaint, the village council also issued. And village council, instead of filing FIR, submitted to the department that we did not issue.
Correct.
So the issuance of the appointment order basing on the land ownership, that means is we are withdrawing, we have not issued, but then why you have given the question mark to the department? It is the department who is to clarify now. Who is to clarify that on the basis of what? Because if it is not on the basis of the land ownership, then on the basis of what the department has appointed her.
In my considered opinion, Your Lordship, the appropriate procedure would have been approach the police, concerned police officer.
No.
And then as the
Department is not saying. Department has to say something. We have believed the application submitted by the petitioner, by you, that believing that this is you are also ownership, and we have inquired also, and then Gauhati also at that time, village council also at that point of time says that it was issued by them, and we believe, and on the basis of that only we have given. Not this is not a case here. You have not said, the department have not said anything. Neither you denied that it was not a force, nor the department says that since it was on bona fide belief, we have given on the basis of the land ownership. Because your basis of appointment is land ownership only, not on any other. And otherwise she is challenging also. Otherwise she is challenging also that on the basis of land ownership, it cannot be perpetuated.
As far as my consent is concerned, Your Lordship, I deny that allegation.
Where?
No,
Let us see.
No, not in the affidavit, but
then.
But again, the other aspect of this case is the onus is on them to prove their allegation.
No,
that it has been forged.
No.
I have not seen any. I have not seen or come across any documents.
No, unless you deny. Unless you deny. That will happen when you deny. That will happen when the department denies. That will happen when you deny. You did not deny.
But on the basis of an allegation, we cannot come to a conclusion to such.
You just deny it. Then of course, then a thing will come. It will go to the police or wherever.
Yes. Otherwise,
FSL or expert. So, but then you did not deny. It is admitted. Unless you deny, it is admitted only. Stand admitted. You got me?
Yes, Lord.
Unless you deny.
Yes.
You did not say even, you did not say no whisper. Not even a whisper. Deny that, no, there was no forgery. I did not forge. You did not say anything. Then it stands admitted only. Then under the circumstances, then department also did not say anything. Under the circumstances, he has a case. Understand? Because it was not during the hearing, but then when you try to write judgment, then this query comes. And then I try to find out. And that is why I try to confirm from you whether you deny it or not.
After the deliberation, I see a criminal case against me, Your Lordship. If that contention is to be accepted, a criminal case, I see a criminal case.
If the criminal case, your case goes.
But
because you are not the landowner.
No, landowner, as far as landowner is concerned, we are all descendants, Your Lordship.
Maybe. But then if you have force, you'll go in a forgery.
Yes. If that's according to the allegation, the proper procedure is filing against or forgery against me. And I'm willing to contest on that. But that has to be
In this case, you are not denying. Neither the government is denying. Then her allegation is that on the basis of this, then how do they, maybe, or probably he denied, probably the government denied the allegation, probably the government did not receive. How do we justify that? Can't do that on presumption and assumption.
But so is the allegation, Your Lordship.
No, allegation is clear.
So is the allegation.
I think there is a
But
clear
it has
allegation.
been, they have yet to establish a case beyond reasonable doubt, Your Lordship, and the honest is
No.
person
Beyond
who is
reasonable doubt is in
alleging the offense.
No, that of course, in the forgery case, then of course it have to be proved beyond reasonable doubt. This is not a forgery case, but then there is an allegation that you have been, you see, you should not have been appointed on the basis of the land ownership because you are not ownership, and then you are not the owner, and then the certificate produced by you submitted before the department, the very basis of your appointment on appointment is obtained by forging the signature and using the paper. I mean what was that? The paper.
Writing pad.
They are writing pad.
That was the allegation.
So you have not denied. I did not do. You check. You did not file. You have not said that you did not file a FIR. You also did not say that you file a FIR. But so long as it is not proved, we'll go by this. You did not say. Had you said, then of course, then it is on us, on her to prove. Got me? It is not a case.
But not admitted also again to the allegation.
You did not deny.
Of course.
Whether admitted or not, that is not the
If it is reflected
question.
to be admitted, of course, that is one principle applied here, Your Lordship. But this is a
no.
allegation
What is the
against me.
principle? Either you admit or deny. Specifically,
I have
the
to
allegation.
deny, Your Lordship.
Hmm?
I have to deny this all.
Yes.
allegation, Your Lordship, but
You did not deny.
Yes.
Either you
Yes,
have
of
to.
course,
You have
it is
two
in the
choice.
document.
Either to admit or deny. You did not admit. You did not deny. When you did not deny, then it's treated to have been admitted. Specifically, because allegation is clear. You did not deny. Unless you deny, it is admitted.
But
it has to be specific.
the finding.
CPC.
Yes, Your Lordship, but the finding arrived from this that it will amount to admitting if I don't deny it. That means a criminal ingredient is also there in the allegation, Your Lordship.
Yes.
It has to be justified beyond reasonable doubt.
No. Now you see. Now the appointment itself, you see, fraudulently you obtained the appointment order then, and in connivance with the department, it has to go that way only because their allegation neither you nor you deny. It stands admitted. If it stands admitted, the forgery stands admitted, then your entire appointment on the basis of which it was done will go. Isn't it? Think about it. Because I think.
May I please, Your Lordship? My Lord, since in this regard, the department has not justified, and I have not received any instruction also, what action they have taken. So, Your Lordship, may kindly allow me to obtain instruction, what action they have taken in this letter.
Better.
Yes. So, a specific direction may be.
Because there may be something, because representation was submitted by the Gambura, the concerned Gamburas, sorry, the village councils, and then some or other action or some steps must have taken and may have discarded also. This is false complaint. May have discarded also. And then it is on the part of the advocate to obtain instruction, the parawise. In the parawise comment, I do not know whether you are still having or not. In the parawise comment, it must have been given because the parawise comment you must have received from the department.
In the parawise, I have not received any instruction in this regard.
On what basis you have filed this affidavit?
No, parawise, I have parawise comments I have received.
Then,
but in this allegation, that specific justification, what?
No, at the time of filing, you should have taken care of
my
that.
Lord, my humble submission is, allow me to obtain the instruction. What action they have taken in this representation? So a specific direction may be issued, my Lord.
No, direction you see, it is you.
Your Lordship,
Direction cannot. We can't.
the department has already received the complaint. May you please refer to page number 46.
No, no,
This is the
your com-
intimation of the complaint letter.
Your complaint is there. You have
No, no, it's a communication between the department regarding the complaint submitted by the petitioner.
46.
Page 46.
What is this?
This is a letter to the Principal Secretary, Health and Family Welfare. Complaint against two appointments made at Yong Gimson under CMO Mokok Chung. Sir, I am directed to refer to your letter number such and such, dated 33/2015, on the subject cited above, and to convey approval of the government in respect of Srimati Tushimala for appointment to the post of medical attendant at Yong Gimson.
This is respondent number 5.
Your Lordship,
Is this respondent number 5? This Srimati
respondent number 5 name is reflected in the second para.
Okay, okay.
Further, the approval convey in respect of M. Lanu Tushi, white letter number such and such, dated 5/9/2014 for appointment to the post of medical attendant at Yong Gimson. CMO Mokukchong will stand as it is. Though they have received the complaint, no action has been taken.
Where do we find the receipt complaint?
Your Lordship,
Complaint received.
This letter, yes, complaint against two appointments.
Complaint against two appointments. No, complaint is, no, this is here specifically because your complaint was forgery.
Yes, Your Lordship.
See that the respondent number 5 is not the landowner. And then the village council did not issue the land ownership certificate to her. So that is your note on that is probably. So that specifically there is, you see the complaint, you just go, where is the earlier document complaint before the department?
Your Lordship, may you please refer to page number 17 also. This is a representation. This is another representation submitted by the village council, German of the village council. May I be allowed to read
Yes,
it,
yes.
Your Lordship?
The 16 and 17.
16 and 17.
You just 16 and 17, Land Council. 16 and 17.
And along with batch 18, this is the declaration. This is a decision taken by the village council regarding regarding the forgery. And the one who forged the signature of the chairman was the father of the respondent number 5. And they have impeached the father of the respondent number 5 from the village council. That's the punishment they have given to the respondent number 5 father.
There is a clear allegation. You should have either denied or you obtain instruction. The next will
Yes.
will pass order, necessary order, because this posed me in a difficult situation that I saw there is no denial, neither by you nor me. And then, but then her claim is that it's a public post. So that again, had it been only this case, would have been, of course. But then not only that, but then her case is only also that your appointment should also be set aside because it's a public post and you are not entitled for the perpetuate appointment as earlier already appointed. So that, of course, that is different, but then here is a different. On this, it will go otherwise. But then you obtain instruction.
Yes, I'll do that.
There is nothing so specific on this. Your case also, you should have taken these points only, I think. The other point seems a little weak. Other point is on the this would have been your strong point.
Yes, Your Worship, but that's the
Okay.
case. That's the case of the petitioner.
Imna Sandler, Land Council for the petitioner. Also had Mr. Mosim sir, Long Kumar, Land Government Advocate.
My lord, I'm E.T. Papu.
Sorry, E.T. Papu, Land Government Advocate. You're a government advocate, senior?
No, junior government.
Okay, Land Government Advocate for state respondent. into the Itiva form, and Mr. I.M. Chen for respondent number 5. Start. After hearing for the matter at some length. Come on. No, just leave it at this stage. Mr. E. Tiba from Lanet Government Advocate. Prays for some time to obtain necessary instruction with regards to the allegation of forgery. Just a minute. Where is the application to the department? 7 page. Page 17.
16 and 17.
16, okay.
Your Lordship, page 19 also. This is an
regards
application on behalf of the landowner.
With regards to the annexer D, E,
F,
and F. And whereby whereby no, D in F, comma, the representation submitted by the petitioner before the respondent authorities. Start, You specifically obtain instruction in this regard that what they have done.
Yes.
Only that. No? So what they have done, the reply, if there is any, and then only that probably, and then thereafter what will happen not be required. But then what they have done in this regard, if there is document, the government has taken steps on this. If no step has taken, no new step required to be taken.
Yes.
So as prayed, comma, the prayer is allowed. List is matter.
10-6 allowed.
10-6.
Yes.
I have heard. 10-6. Will it not be listed as a part hard? 10-6 part hard, it may not be possible. I will not be there. List this matter after next week. Thereafter.
31st, then, my lord.
31st. 31st. Yes. We'll fix on 31st. Okay. 31st is what day?
Friday, my lord.
31st is Friday. We'll fix on 30. No. 30 there is fixed matter. Okay. Then 29 is DB. 28?
My lord, because day after tomorrow is holiday.
Okay.
And so.
Okay, list is matter as a part hard after. Okay, 31st we'll say.
Yes.
We'll try because it's fall on the last date. Last date probably may not be possible for hearing, but then any fixed matter on that day? So it will be because less matter. Hearing may not be possible since it falls last date. So this is in the hearing column. No. As a part, this is matter after as a part hard as and when this court sit after 31st. Yes. After 31st, any date. Okay, as and when sit. Or you want, don't want this to be kept as a part heard?
The matter has been heard at length by this honorable court, sir.
A choice? What do you want? Not as a part heard?
Yes, Partat. Partat.
Part heard?
Yes.
Okay, because I have heard. I know the case. Okay. Finish. Anything else? We could have then taken that method. Sent back. Anyway. It's just. This is in that.
Kamera tidak jelas. Tidak lain dan kamera tidak jelas.
For one Kohima, and that's. First time. Continue go by so